There's at least 100 still short.
Really?
Yes, we have
Excited to have a meeting.
Yeah. Okay, I see. Let me just see how many more we're expecting.
Sibongile, please mute.
I don't know whether we should just give a few minutes. I'm going to just check the chat quickly. Okay, I just see everybody's giving some greetings there. We have a lot of slides to get through. It's death by PowerPoint, unfortunately, but I promise you that the PowerPoint presentation really helps. It, especially for those learners that are really visual, it helps with them, and also the kinesthetic learners. You know, there's different types of learners, so that would help. But what I have noticed is that just trying to speak and not having a PowerPoint isn't the work. The students don't grasp it well. So death by PowerPoint for sure. But I promise you, by the end of these 2 days, you will have really grasped some groundwork, at least the basics of road accident fund claims. And that's going to help you for future as well, for future claims when you are in practice as well. So it's really going to be helpful. So I'm going to give the colleagues maybe a few more minutes but I think we definitely have to start by in another 2 minutes or so. I did send Ms. Suki Swakala the slides that I'm using for today, and hopefully you all have them. Do you? Yes, okay. I see there was a thumbs up from someone. Okay, so that's great. You all have them. This is how we can do it. What I've done in the previous semesters is that I will give the presentation. So as we go through each slide, I really prefer to rather let the colleagues ask questions. So be interactive in that sense. Before we move on to a new slide, we rather make sure that we've grasped that previous slide. I don't want to have anyone in the position now where they are completely lost. And you'll see me, I'll keep asking you every time, colleagues, are you following? Are you following? Just give me a heads up, you know, that we are doing fine and everyone's following. Sometimes some of the works is very technical and I need to repeat it. That's fine. I will do it until you understand it, because it's very progressive and logical in the way I've set it out, and we cannot miss concepts that will become harder to understand later on. So that's the way I'm going to do it. Is that fine with you, colleagues?
Good evening, Ms. Rahil. It's Mr. Kruger here. How are we doing to this afternoon, or rather this evening?
Yes, this evening. I'm good, thanks, and yourself?
Good. Thank you. I'm saying this with you know, not to come off bombastic, but you know, the we as a class have been we've progressed with this lecture and what through this course, and so far what we usually did was at the end of a session, you know, we don't mind questions in between, but we usually like questions out of curiosity, or in this kind of scenario, we usually leave till after class. But if it is a relevant question to the slides, we don't mind as much whether we ask it in between and all of that. But just from my side, out of curiosity, I'm not sure what your title might be. We've had a judge, we've had advocates, we've had professors. So I think just for clarity, how may we address you? As ma'am, counsel, advocate, my lady, your worship?
No, I'm definitely not an adjudicator. I am just an attorney, but I'm a professor actually, from UNISA.
Okay,
So
okay.
yeah.
Okay,
I
well, thank you very much, Prof.
Okay, no, it's fine. So, colleagues, I see that everyone's cameras are at least disabled, because that can be a bit difficult to deal with the lecture going forward. Your mics, you can use them, but colleagues, I think just let's be very careful in the questions we ask. If you're really lost in a slide and you're not understanding, definitely shout out. So when I put the PowerPoint presentation on now, it's going to be on a slideshow. So the biggest problem I have is that I cannot see what you're saying in the chat box, because I'm just presenting directly from the slide. So I don't mind if at the end of the slide, you just shout out and just ask your question, okay, going forward. And then somewhere in between, I have included a break. But if it's really getting bad now, you are really exhausted and you need a cup of coffee or tea, then we'll do that.
Apologies, Professor. Mr. Kruger here again. Sorry for interjecting. We usually take our break at around 7, there around. I'm not sure if you'd be comfortable with that. We usually take about 15 minutes or so.
We can do that for sure. What I did do is I tried to include it in the presentation somewhere, just so that we finish a certain section. But just to remind me at 7 now if I've gone past the time.
Of course, Professor. It's at your discretion. We understand that it's not a guarantee. It's more of a convenience. So we'll take it at your pace, no problem.
Yeah. Okay. Okay, colleagues. Let me begin. I've just minimized my chat, so I cannot see your chat. So please just shout out if something. Maybe you can't even hear me. I've lost you. We've lost connectivity or whatever the case may be. But yes. Okay. I'm Raheel Ahmed. I'm from UNISA. I have been there for, I think this year might be 15 years, if I'm not mistaken. When I was in practice, I really was in a firm that focused really on personal injury claims. At that time, it was the bread and butter of the firm as well, or at least one of the sections that brought in income. And that was a very busy part of the work. I had dealt with the road accident fund a lot, with assessors, etc. We used to work for the panel, actually, for the RAF. The RAF has been in the news a lot lately. They've even considered it a state of disaster at this point. But we've just got to keep abreast, keep listening to the news, because things change. There's things that are being challenged at the moment. So even though I might give you info now, some things might be challenged, and you've just got to keep abreast of it, okay? In time, in the future at least. Okay, first slide, colleagues, here we go. So as a disclaimer, I want to say already that everything that's contained in the slide doesn't cover everything that's in your practice manual or your training guide. What I'll do is I'll focus on the important aspects of personal injury claims. With regard to this area of the law, it's quite vast in the sense that it covers road accident fund claims, but also public liability, because we're suing the state sometimes. You could be working for either or, the state or the client. The Passenger Rail Association, abbreviated PRASA, unlawful assault and arrest, liability that stems from injury caused by animals, that could be domesticated or non, grazing animals. Then we've got professional negligence, which I know is covered more fully elsewhere. And under that, they do also cover contingency fee agreements, but we'll just touch on that. And then the other thing is medical negligence. Medical negligence is also becoming a very large growing area of the law at the moment, and especially with litigation and even unlawful arrest. We've seen a lot of cases come to the courts now with unlawful arrest and medical negligence. That seems to actually be almost taking over road accident fund claims. So yes, the slides have been made available to you. And also, I just want to say that I do not follow the order exactly in the practice manual. I try and do it in a way that's more logical for me, coming from the background of law of delict and damages. Those are the areas that I do teach. I did teach law of delict, law of damages, and at some stage, UNISA was offering third-party compensation law. And we scrapped that some years back because we foresaw that there's going to be a lot of limitations that apply, and in practice, it's going to become less and less work for the attorneys. Nevertheless, I'm going to continue with that. So in terms of road accident fund claims, and colleagues, another note, disclaimer here, even though I've got paragraph numbers here, the paragraph numbers are probably fine, but your page numbers, apparently you get a hard copy and an electronic copy. Sometimes the pages have different numbers, but I'm sure we can follow according to the paragraph numbers. So anyway, it's according to paragraph 1.5. The law relating to motor vehicle accident claims is a blend of different areas of law. Remember, I spoke about delict. That's really the backbone. And there also, we should have put the law of damages, because that forms a massive part of quantifying damages. So law of damages is important. It also covers insurance law and socio-economic legislation. That's just a broad term covering different legislation. And the RAF basically incorporates different areas of the law. You'll see sometimes you'll have to deal with the law of contract. Sometimes it's family law. For example, if you're trying to decide who has locus standi, law relating to husband and wife, etc., where you have to appoint curators, law of delict, law of forensic medicine, medical malpractice claims. You can have concurrent claims in the sense that imagine a scenario where someone is drinking and driving, or they're under the influence at the time of some alcohol or a substance, and in that they do cause an accident while driving a motor vehicle. So there you can have a concurrent claim in terms of you have a criminal case going on, and then you have a RAF claim going on, and then you might even have a damages claim separately going on. And then there's magistrate and high court practice rules as well that apply. So you've got to remember the difference between that and then obviously just general attorneys' ethics, etc. So there's a lot that's covered in this. It's very broad. I think the one thing you'll figure and notice in practice is when you were studying your LLB, you learned everything in sort of silos. It's like this area of the law and that area of the law and that area of law. And now you come to the stage where in practice, you get such a complicated case and you're like, whoa, I need to check this area of the law and that area of the law and so on. So yeah, that's just an intro, colleagues. Are you still following me?
Yes.
All right. Okay, great. Now we're starting with the hard part. So I need you to focus and concentrate because this is a statute that we really need to comply with. So first of all, in your practice manual, you'll see under paragraph 1.4, there are specific dates, and these are time periods where different acts apply to road accident fund claims. So from the 1st of May 1989 to the 30th of April 1997, they had the Multilateral Motor Vehicle Accident Funds Act. So imagine now an accident that happens during that time. That is the act that will apply. I doubt you're going to come across that in practice, but I'm just explaining that to you. Then the second time period is 1st of May 1997 to 31st July 2008. That one there, you apply the Road Accident Fund Act, number 56 of 1996, and that's got specific regulations there too and specific forms. That's an important one I want you to remember. This is the preceding legislation. So you'll notice throughout your guide, they have this reference back and forth to preceding legislation, which means before the 1st of October, 1st of August, sorry, 2008. And then you get the current legislation. So preceding legislation is before 1st of October, why do I keep saying October? 1st of August, 2008. Then the current legislation that is applicable right now, basically from the 1st of August 2008, it's a Road Accident Fund Amendment Act. And that also came with a number of amended forms. And as of yet, they've even amended the forms again with a directive. But that is in your notes. You've got the current forms there as well. Then government has been discussing already future legislation. That is the Road Accident Fund Benefit Scheme. So they've got a bill out and they've explained how it'll work, but we'll deal with that a little bit later on. For now, I just want you to remember, colleagues, previous legislation, remember, before 1 August 2008. Current legislation, any accident that happens from 1st of August 2008 onwards is current legislation. All following?
Yes.
Right.
Yes. Swear.
Okay, good. Okay, as an introduction, now this is really important. Anything to do with road accident funds or any accident that happens on the road in South Africa, basically, the RAF steps into the shoes of the wrongdoer driver. That means that you can't sue the wrongdoer driver. You have to lodge your claim with the RAF. right? And then you're obviously claiming for compensation for your injuries. Now remember, it's only related to personal injuries. So it's got nothing to do with what happened to your vehicle, there was a laptop broken in the vehicle, or whatever the case may be. Anything in the vehicle or the vehicle itself, that becomes a separate claim, and it's a damages claim that you'll lodge, or you'll actually start with an action proceedings, and that you can have running concurrently as well. So I'm going to start with the RAF Act prior to the amendments, right? The preceding legislation, remember, before 1 August 2008. And thereafter, I'm going to focus on the current legislation. And then last, towards the end, I'll just mention a little bit on that bill. Okay, now we're going to confuse you even more. So we need you to concentrate here. We are dealing with preceding legislation. What is the date for preceding legislation, colleagues?
July,
For August.
31st July 2008.
Okay, so preceding legislation, colleagues, is before the 1st of August 2008. So everything in your manual that states preceding legislation, it means an accident that happened before 1st of August 2008, right? So when you get a client, or let's just say you've got a case in front of you, the number one thing you've got to do is look at the date of the accident, because that's important. But right now, it's very rare that you're going to find a case where we're not working with the current legislation. There can be instances where it's been a minor maybe involved and you're still dealing with the preceding legislation. So we have to explain to you the provisions of that preceding legislation, just so that you are aware of it. Are you following? Colleagues?
Yes, his hand's going up.
Yes, ma'am.
All right. Right. One of the complicated bits in the road accident fund legislation always dealt with passengers, right? So according to the preceding legislation, it was very important to figure out what type of passenger that person was. Whoever claimed that passenger, it was very important to figure that out. But to begin with, the question was, how do you know somebody's in a passenger? And there it became about the meaning of convey. Conveying means entering a vehicle or a bus. Just imagine you are stepping a foot on the bus, or you just a foot off the bus, let's say. That means already convey, basically getting in and out of a vehicle or in and out of a bus even. And there also it was important to state what was the intention of the parties. Were they intending to be conveyed? And it was just basically a factual question that had to be decided on the merits. It never really gave problems, but there were like rare cases where somebody stepped off a bus or stepped on a bus, but nothing too complicated there. Continuing with the limitations, right? Remember, limitations does not mean a total exclusion. The difference between an exclusion is it outright excluded from the beginning. But a limitation is something where there is a claim, but the claim is limited, basically. So continuing with passengers, this is important, colleagues. I will not move from this slide until you all understand. According to the passengers, right, their claims were only limited under this golden rule. Either it was a single motor vehicle accident. In other words, imagine the scenario of somebody driving a vehicle, your client drove a vehicle and or a lamppost or a street light, for example, right? There's no other vehicle involved. There's not a pedestrian involved. It's just a single motor vehicle accident. Or the other instance was the driver of the motor vehicle, where the passenger is, was the sole cause of the accident. So there you might have had an instance where there were two vehicles involved, but the driver in which the passenger is was solely responsible. In other words, 100% negligent. And then in those instances, in those two situations, right, the claims were limited to 25,000 Rand. So they actually had a capped amount that applied, and that was 25,000 Rand. So imagine you had a vehicle with 4 people in, 4 passengers, and they all wanted to claim now, but they could claim, their claim was limited to 25,000 Rand each. That's just a basic principle for now, colleagues. Are you following?
Yes.
Yes.
Professor, we are indeed with you. Sorry,
Yes,
Prof, if
ma'am.
you don't mind me asking, there's a lot of reaction on the Microsoft Teams platform, like thumbs up and things as such. Can you see it from your side, or
No,
would you
not
prefer
at
us
all.
verbally confirming? All right, understood.
I
Thank
can't,
you.
that's why I need you guys to please shout out for me, because what I'm seeing on my screen is a slideshow. If I go and try and minimize this, then you will, because I'm presenting, in other words, you're going to have a shortened version of the screen.
Okay,
So
thank you very much for the
I
clarity,
can't see
Prof.
it. Yeah, just shout though.
Will do.
All right. Okay, continuing with the limited claims, and still remember preceding legislation. Now, if there are two motor vehicles involved, right? Two motor vehicles, but if the passenger can prove even 1% negligence against the other driver, then the claim is not limited. So here, I just want to imagine the scenario. There's two vehicles involved. Let's think of an example where there's a stop street, and the first driver, driver A, comes to the stop sign, and the other one also comes to the stop sign, driver B. Driver A continues forward through this past the stop sign, and driver B does the same. Coming to the time of the accident and their versions of the story, driver A says, no, but I had stopped first and I had the right way to go. Driver B says, no, but I stopped first, I had the right of way to go. Now there's passengers involved in driver A's car and driver B's car. Now because normally in the courts, what happens when there's two mutually destructive versions, in other words, both witnesses are saying that one did it and that one did it. I had the right. I had the right. Usually, it's not a hard and fast rule though. If there's mutually destructive versions, the rule was really just apply 50% negligence to both. So there you've actually got more than 1% negligence. Those passengers in the vehicle could claim, and their claim wouldn't be limited to the 25,000 Rand. Are you understanding that?
Yes.
Yes, ma'am.
Brilliant.
Yes.
Section 18, now we've got subsections here, right, with our passengers. So section 18, subsection 1A, there we had a list of passengers. We had the passenger for reward, that means a paying passenger conveyed in the course of the owner's business, passengers conveyed in the course of their employment where COIDA applied, passengers conveyed who are part of a lift club. Colleagues, somebody's mic is on. I think they probably don't know. Okay, great. Okay, so we had these different list of passengers, and their claim was limited to 25,000 Rand, but special and general damages. Can anyone tell me, just out of their head now, on the spur of the moment, what is the difference between special and general damages, if you remember from your law of damages?
Professor, from my venture, I believe general damages would be anything relating to medical claims, your medical expenses, those kind of general damages. Special damages, I believe, relate more to future loss of income, loss of amenities of life, and those are the two off the top of my head.
Okay, so let me just clarify it for you, but don't stress, because later on we will give you a really nice breakdown of what's the difference between special and general damages and what kind of heads of damages fall under that. Now, special damages is something that you can quantify in money easily, right? You can put a figure to that. In other words, if it's a hospital bill, a past hospital bill, you can put a figure to that. If it's a future hospital bill, still you can put a figure to that because they will give a projection of what the estimated cost will be. If it's past of loss of earnings, you can put a figure to that. Future loss of earnings, you can also put an estimate and figure to that. But general damages is something you cannot easily quantify in money. And that we talk about, can you remember emotional damage and emotional harm? Loss of amenities of life. Do you remember all that?
Yes, Prof.
Yes. So that's the big difference between special and general. Now, those passengers, they were limited to 25,000 Rand, special and general. So let's just say special damages came up to 100,000 and general damages, they claimed 12. So whatever the case was, they were still limited to that 25. Then subsection 18(1)(b). That one applied to passengers who were not classified under subsection A above. So basically, they were just regarded as a social or gratuitous passenger. In other words, it's just your friend traveling with you or your child traveling with you. So they weren't paying money or not in the scope of employment, etc., not part of a paying lift club. They were just basically social passengers. Now, for them, a further limitation applied in the sense that their claims were limited to 25,000 Rand, but only special damages, right? So they could only claim 25,000 only special. So that was normally the social passenger. Are you all still following?
Sorry,
Yes.
Prof. Just if I may. So in terms of the Roman numeral small I
Mm.
and 4.
Yes.
So it was limited to 25,000 Rand for
Yeah.
special damages and 25,000 Rand for general damages, not
No.
25,000
A
for
total.
special and total between the two.
Yes, it was a total of 25,000.
Okay, thank you.
Yeah, no, thank you for actually asking that question. So at least it's clarified. Okay, so now we managed to understand the previous legislation and section 18. We managed to get that down. Now, there was the Road Accident Fund Transitional Provisions Act. Now, this one here, it actually emanated from the case of Mvumu and others versus the Minister of Transport. And what happened was section 18(1)(a)(b). Let me just go up again. That would be our social passengers. It said, you know what, we're finding it unconstitutional, this legislation. So it went to the courts and the court said, you better rectify this legislation, but in the meantime, we're just going to give you some transitional provisions to comply with. So I think at this stage in time, it's not even applicable. They cannot decide what to do with it, but it's just for noting that on the 13th of February, the Road Accident Fund Transitional Provisions Act came into operation. There was a government gazette notice. And in terms of the act, the claimant, which is subject to a limited passengers, they could elect to have their claim either subject to the Road Accident Fund prior the amendments or the current legislation. So they could decide, okay, I want my claim dealt with in terms of the prior legislation or the current legislation. This election could have been made, obviously, if the claim wasn't yet finalized or settled. So the claimants had the right to claim general damages, but again, it was limited to 25, but unless the claimant's injuries are deemed serious. And that is in terms of the current legislation. Don't stress at this moment what that means, because I definitely will explain that to you later. You will need to know that because that's the current legislation. Now, a claimant intending to claim general damages above the 25,000 must ensure that they had submitted the RAF 4, and that was before midnight on the 12th of February. They had to notify the RAF on the prescribed claim form, and they had to actually break down and state what compensation they had received already. So one of the biggest things is, what did you receive from COID Act, basically? What did the Compensation Commissioner already give? And they needed to know what was amounts were already paid. Remember, with state and state liability, they don't like, or even just a general principle in law, you cannot be compensated twice for something. So they always asked for what did you already receive in terms of, it could have even been a supplier's claim or interim payments. What did you receive already? And what did you receive from the Defense Act in terms of the Defense Act or in terms of the COID Act? And then these were deducted from the final compensation that the RAF then awarded. Okay, still following there. Then we had section 19, which dealt with an exclusion, and also your current legislation, section 18. Now, in terms of the previous, in terms of the preceding act, right, there was section 19B, Roman numeral 2. If you were a member of the household and liable for maintenance of the driver, you would not be allowed to claim. So here I'm going to give you an example of, I'm driving in the car with my son. and I'm involved in an accident. It doesn't matter who's to blame. Maybe I'm to blame as well. But my son who is in the car, let's just say I am the one that's responsible for this accident. I skipped the red robot and I went through the red robot, and there we go, accident happened. My son actually couldn't claim. And it would be the other way around. If my son was able to drive and he was driving me and I was hurt in the accident, I also wouldn't be able to claim. Now, that was one of the provisions in the Act that was allowed, but then the current legislation, in other words, the legislation that's applicable now, and also because of the case of Vanessa De Silva, the court said that all passengers' claims are no longer restricted to the 25,000. And this applies to claims which occurred after the 1st of August, but it also applied to this provision of 19B2, basically. So in other words, now, if you're involved in an accident and you're dealing with a member of the household that's responsible for you. So I'm the mother, I'm responsible for my son. He can still claim, and the other way around. So there's that limitation's been removed. Are you still following, colleagues? Dealt with members of the household. Colleagues?
Yes, still following.
Yes.
Yes, following.
Okay, good. I have to check on you so that
Sorry.
you're not. Yes, I have to keep checking on you, colleagues. You're going to get so irritated of me asking you, but I need to just keep checking because I cannot see whether you've got thumbs up going there. Okay. Section 17 now. This section now deals with general liability in terms of the Act, right? There's two types of claims. Right at the outset, know this. There's two types of claims. You get an identified claim. That is where you actually know who the driver of the vehicles are. And then you get unidentified claims, also called hit and run claims. With the hit and run claims, you actually don't know who's the driver of the vehicle at the time. So there's two types of claims there. Requirements for all claims, right? Number one, the claimant must be a third party. So the road accident fund, and this also is broken down into two. There's two types of, let's just say general, two types of third parties. The first type is the one that's personally injured. So I'm the one that's personally injured. I had an accident, I've broken my fib or whatever the case may be, had a slight concussion, I had whiplash, whatever. But I was personally involved in the accident and I was personally injured. So I'm a third party. Then you get third parties that suffer loss, but that is due to the injury or death of their breadwinner. So let's just say I'm a single mom and I am the breadwinner of this house. I have 3 dependents, my 3 children, they're all minors, they depend on me. So let's just say, for example, God forbid, of course not, touch wood, I die, and then my kids are left as the dependents. They've lost their breadwinner. They are allowed to claim from the road accident fund. Or a scenario where I'm hospitalized for now 9 months. I haven't been able to earn an income because my work says, sorry, Prof. Ahmed, you've used up all your leave. We cannot take this anymore. We need to find somebody to fill in your place. So I could have lost income for that 9 months. And then also, I don't know when I'm going to find a job. So they also are suffering loss now because of my injury in this accident. I'm in hospital or whatever the case may be. So 2 types of third parties there and 2 types of different claims, right? Okay, the next requirement is an important one. It's conduct, right? And there the Act refers to 2 types of, again, broad categories of conduct. So the first one is driving, right? You think that's simple enough, but it's not simple enough because the term driving is now extended in its meaning. So section 20 refers to presumptions, and they extend the meaning of driving, and it includes things like pulling a motor vehicle, pushing the motor vehicle, pulling it by hand, whether it's pulled by an animal, even a motor vehicle moving by gravity, like you put the handbrake up on a hill, handbrake's not working and the car rolls down. That's also considered driving. So driving is not the normal term that we know, but it's actually got an extended meaning. So there you just look at section 20. I know one of the common ones we used to have in practice is the car rolling down the hill because the handbrake wasn't up, and then it was considered driving. So that was one of the interesting ones. Then the other form of conduct you get is another unlawful act. Now here I want you to imagine the scenario of a wheel becoming dislodged from the vehicle in front. It rolls down the road, and then we've got a mass of cars just trying to dodge this rogue wheel that's gone off. Accidents have really happened from that. So other examples are vehicles skidding on spilled diesel, and then they collide with another vehicle. There were some strange cases where allowing a drunken person to travel on the back of a lorry, which the Road Accident Fund accepted, was conduct. Colleagues, are you still hearing me? I'm hearing sounds from my thing as if we're losing connection.
Loud and clear.
I
Bob.
hear you clearly.
Hear you?
All right. All right.
Yeah, we can hear
Loud and
Okay, great, colleagues. Okay. So yeah, one of the strange cases was allowing a drunk person to travel on the back of the lorry. But these are the cases that are actually specifically mentioned even in your practice manual. They give the example of general accident insurance versus SECO, Wells versus Shield. So yeah, just always have a look at that. It's never always straightforward, the cases that you get. And then the concept of a motor vehicle. What actually qualifies as a motor vehicle for the purposes of claiming from the Road Accident Fund? Okay, given it includes a bus, a taxi, a normal motor vehicle, right? So when the Road Accident Fund gets new and novel cases, for example, a forklift or some abnormal vehicle that they need to classify, it caused an accident on the road. So what the courts do is look at 3 tests, right? The first one is the propulsion test. In other words, how was that vehicle propelled? Is it petrol, fuel, diesel? Nowadays even can be electricity. Then the second thing was the design test, and this was an objective test, right? It's objectively viewed, was this vehicle designed for use on the road? In other words, does it have a hooter? They looked at things like speedometer, indicators, headlights, etc. Then the third concept that actually had a bearing on what qualifies as a motor vehicle was the concept of road. And there the Act is very generous. It doesn't mention or provide limitations. It just says it's a surface prepared for the use of vehicles and pedestrians, and it links 2 places. And when it's come to the courts to understand what is basically called a road, we've had them actually agree to parking lots in private areas. It could be in a shopping center or even in a private hospital. So there the concept of road is really wide. I haven't seen one where they've declined something because it didn't qualify as a motor vehicle because of the concept of roads. That's a really wide concept. They're very generous with that. So here are some examples of vehicles that were not considered to be motor vehicles. And one of them is the forklift, the ride-on lawnmower, the midget racing car, the go-kart, a self-propelled vehicle designed to provide power to a jet. I think even something to do with aeroplane runway as well. And the ones that were considered to be motor vehicles. Very recently, there was a case where they said a reach stacker is considered to be a motor vehicle, a Caterpillar 769 truck, a pneumatic tire roller, a 6-seater golf cart shuttle, and even a quad motorcycle. So yeah, there were instances that they said, yes, these qualified as motor vehicles. So you've got to always just check the case law. But for now, I think it's quite up to date, the material, but in future, it always gets tested by the court. Every couple of years, something comes up. There was, just for your own, if you're in practice and you want to figure things out, but I know that Prof. Steinberg and I, some time back, we wrote about the quad motorbike in one of the cases there. Then in terms of the conduct itself, right, it must be that of the owner or the driver of the motor vehicle. And you need not have the driver's consent. So even somebody who wasn't allowed to use the car or somebody who stole the car, it will still be considered as conduct. And that also applied to the employee who was acting in the course and scope of employment. So it's really trying to benefit the victim here as much as possible. And then conduct, the yardstick that was applied was negligent conduct, right? And remember from your law of delict notes, colleagues, the reasonable person test. So if you stray from the standard of the reasonable person, yes, then it becomes an issue. Remember, negligence is the failure to exercise the degree of care and skill that the reasonable person would have exercised in the circumstances. When you apply the reasonable person test, we look at the position of the driver at the time. So I don't want to confuse you too much into concepts, but it's an ex ante approach. In other words, it's at the time. It's not after the accident. It's really just an ex ante approach. And here, remember, colleagues, from your law of delict, reasonable foreseeability of harm. And would the person have taken steps to guard against it? If they fail to do it, then the person is negligent. Do you remember?
Yes, indeed, Prof.
Okay. Right, how does negligence actually get proved or proven? Number one is prima facie negligence. Number two is the maxim called res ipsa loquitur. I don't even know if I've pronounced that correctly. I think Prof. Knoble will probably be laughing at me now. But in this case, it means the facts speak for themselves. So just to give you an example, there was a case actually where there were two motor vehicles involved. It was in the night on a road that's not very busy. There were two motor vehicles involved. And what happened was, according to the evidence, the one car had moved from its side of the lane onto the other side of the lane. And both of the drivers, there was only two drivers, by the way, so there was no passengers and absolutely no other witnesses. No passengers, no witnesses, but just the two drivers. And what happened was the one driver actually died in this accident, and the other one fell unconscious and couldn't recollect how the accident happened. So when it actually came down to it, the other driver that was still alive couldn't understand or couldn't remember how the accident occurred. But there was a presumption now that the facts speak for themselves. If the vehicle moved onto the wrong side of the road, it's most likely that that vehicle was at fault. So that's sort of one of the ways where if you have no other evidence, then that's what you have to rely on. It's not always something that the courts allow, to be honest. I remember even being in one case where we did have an issue where we had a driver that knew what happened, or he gave his version, and the other driver says, no, he was unconscious. He couldn't remember what happened. He lost his memory for that point of time. But the judges seem to always give leeway. They don't like to just say, okay, no, for sure, the facts speak for themselves, and that person was negligent. But that's just one of the maxims that are applied. And then if you remember, colleagues, as a difference from criminal law, when you're dealing with the law of delict and road accident fund claims, you have to prove it on a balance of probabilities. So who provides the good version, the better version, basically? Or if there are witnesses, when the adjudicator is there, whether it's a magistrate or high court judge, they will really rely on the witness and whether the witness made a good impression and sounded like, their expression or their explanation of the events was the most probable one. Okay, and then the damage or prejudice suffered must be due to bodily injuries. And remember, I said to you earlier, you either were personally involved in the accident or you suffered harm or loss because of the death or injury of somebody else, being your breadwinner. Okay. Remember earlier I said that you cannot claim for lost luggage, for example. So let's just say in an accident that happened, you had a boot and it was full of luggage, your spectacles got broken, your false teeth got lost, for example. That just generally, the road accident fund doesn't cover that. That will fall under a separate damages claim. And there also you'll use the principles of law of delict as well as the law of damages. But if the accident happened and let's just say your teeth were perfectly fine, you had a good set of teeth, nothing wrong with them, But you had this accident now, and now you've got some broken teeth and you need some surgery. Maybe you need to see the maxillofacial surgeon. Remember, under those scenarios, there the road accident fund will state that, okay, yes, you are allowed to claim. The point is, what is the point in terms of the law of damages? It's always to put you in the position you would have been in had that accident not occurred. It's like with insurance claims. If you have you claiming for something broken in your home, let's just say it's a toilet that broke, for example, and when they come and fix it or repair it, they've got to replace it with something that's to that value, so that it would be as if it did not happen or the incident didn't occur. Colleagues, you still following me?
Yes, Prof, I've got a question. It's Tolofelo here.
Yeah, sure.
What happens in the instance, let's say you're using a state car and you get involved in an accident at the time when you are not even supposed to be driving the state car? And let's say you've got even other passengers that are not even supposed to be on the motor vehicle. Does that count for those passengers? Let's say I was a passenger in a
Yeah.
state car, which I should not have been in.
Yeah, they will. Remember, they are the innocent victims. The passengers are the innocent victims, but it will probably be an issue with COIDA. I think the COID Act as well, or maybe even the Defence Act, if we're looking at what that whether you are part of the military or whatever the case may be. But the passengers will still be allowed to claim. So remember, I said to you, even if the person was unauthorized to use the vehicle, or a person was a thief and stole the vehicle. So, and the accident still happened. It's still considered an accident. It still happened. So even though those underlying consents, if I could say, I don't know if that's the correct word, or authorizations are not there, that won't hold it back, or it won't really limit the claims to the road accident fund.
Okay, so Prof, means then it would be the driver who can't claim, or it would just affect him on the COIDA. Because remember, you explained that we look at who was negligent, and let's say in this instance, it's not the driver using the state motor vehicle who's negligent, it was the other driver. So would they be able to claim, or they will be?
They
okay.
would.
All right.
Yeah. So
Thank you.
if you have a situation like that, yeah, remember, if you can just prove even 1% negligence from the other driver, you are entitled to claim. So if you're a driver and you're also involved in the accident, you're also to blame. But if you can just prove even 1% against the other driver, you're entitled to claim. So one of the questions I do remember back those days in the board exams, they would say they would give a scenario: this driver is driving under the influence and skip the red robot and cause an accident. Can this person claim from the road accident fund? And the answer to that would have been, he's the author of his own misfortune. Besides it being a single motor vehicle accident, he's 100% negligent for this whole incident. Yeah, but if you can just prove 1% even from the other driver, you have a claim. Does that answer it, your question?
Yes, thank you so much, Prof.
Okay. And thank you for asking that question. I'm sure that somewhere along the line it would have been asked or it would have come across somewhere. Then the other requirement, again, this is still a basic delictual principle. There must be a causal link, right, between the damage or the prejudice suffered, the damage or the harm. And there, colleagues, I don't know if you remember from way back, Law of Delict third year, remember such a principle called factual causation and legal causation? Yeah? Anyone remember?
Yes.
Yeah. So most of the time, causation is not a big issue, because factual causation, you're basically following one fact onto another and you're able to prove it. There's never issues with factual causation, but there's always issues with legal causation. And there we look at principles like, was there novus actus? In other words, was there a break in the causal link? So just to give you an example, there was this case of Road Accident Fund versus Russell. And here the claimants are husbands sustained injuries in a motor vehicle accident, and he became severely depressed. He went through some personality changes and actually wanted to commit suicide, and eventually he did. His suicide, even though it was deliberate, remember when you're committing suicide, of course it's deliberate, but the court said it doesn't amount to a break in the causal link. The court held that he eventually caused or she lost the husband, lost a breadwinner, because he was involved in this accident and eventually died, reasons thereof, stemming from that accident. So the court said there was a causal link between basically the suicide that eventually happened, going back to, you trace it back to the motor vehicle accident. That was the cause of it. So in the end, the wife, she was entitled to claim loss of support from the road accident fund. That was one of the very important cases that we had. It was a breakthrough, actually. But yeah, colleagues, you're still following. It's not normally a problem, but sometimes, yes, it can.
We're still following.
All right. Right, here's another one. The accident must occur within the Republic of South Africa. And I don't know why, but I get this question all the time, that what happens if it's on the border of this and that? Colleagues, I think as long as they can demarcate it and say this is land of South Africa, end of story, then the Road Accident Fund can be applicable. The provisions of that act can be applicable, right? Lately, there's been a directive, I think there was a directive that was sent out that said that it doesn't apply, the Road Accident Fund Act doesn't apply now to foreigners who were injured if they were illegally here in the country. And currently, I know for a fact that it's actually being challenged in the High Court. But that was something that we never knew before. We always thought that even if you are illegally here, you were entitled to claim. Then there was a directive that came out that said, no, it doesn't apply to illegal foreigners. And right now it's being challenged. So just look out for that when you hear it in the news, and then you'll, now I get the answer to that, right? So just keep your ear out for that. Then there was a case of Bangiwe versus Road Accident Fund, and it's mentioned in your paragraph 5.31. This was interesting because it dealt with an underground mine. And remember the whole issue about what qualifies as a road or place, in others. And the RAF said that any place didn't mean underground. And there again, the court took a very liberal view and said, no, it does include underground. So imagine it covers parking lots, even public and private hospital parking lots, and even underground now. It's so early, colleagues. It's 6:30. And I've already scheduled a break in my thing. Shall we continue until 7?
Yes, please.
Yes.
Yes, definitely. Probably.
Yes,
We
Paul.
nuance,
Prof, and I have a
Prof.
question.
Yeah. Go for it.
Okay, I'm just gonna take you back a bit. I need few clarity on stuff. So remember when you mentioned the seat belt, that the passenger needs to have had a seat belt on. I wanted to understand if this also applies to people sitting at the back seat, because the back seat or even in a taxi, there are seat belts there, but people hardly ever use the seat belts at the back. So does that seat belt also count? That's the first question.
Yeah.
And
Let
then,
me.
yes.
Yeah. Okay.
Sorry, I think I've got 2 more. And then I also wanted to understand the loss of support and loss of income part in terms of the compensation, right? With regards to the loss of support, I see that it is kept at 100.
Colleagues, did I lose? Sorry, my dear. I think I've lost a bit of connection there.
Oh, okay. Sorry. In terms of loss of support, right?
Yeah.
I wanted to then understand the 160,000. Is it for the whole household or is it per dependent? And then I also don't understand, is it capped at the 160,000 so it does not take into consideration the lifestyle that they lived if in per annum they used more than 160,000? And then the loss of income as well. I think it's that, is it capped at that amount that they've prescribed? And do they take into consideration the lifestyle and the type of work the person had, their skills and all of that? I think those are my questions for now.
Okay, no. Good, really good questions. So what I want to do is the answer to your second question, that dealing with loss of support and loss of income and that capped amount. Let's deal with that a little bit further on under, we're going to get to those sections. But basically, yes, it is capped and it's for the entire family. So if it's capped at, let's just say 180, I think the current value is over 200,000 now. But basically 200,000 Rand has to be shared between the entire family. That's just to answer your question. So they don't actually care if, let's just say you are an attorney and you're earning 100,000 Rand a month. You are going to be capped at that 200,000 Rand per annum. And that's for your entire dependents, basically. But we'll get to that again later. And then your first question with regard to a seatbelt. So one of the things on the claim forms, if you have a look at some stage later on, you don't need to do it now, but they actually ask, did you wear a seatbelt? And the moment the person puts yes or no, whatever the case may be. So if you didn't wear your seatbelt, what they like to do is already apply apportionment. And we'll deal with apportionment just a little bit later on. But there it's saying that, okay, the driver cannot be 100% negligent because the passenger didn't wear the seatbelt, and then the passenger now has to have his claim reduced by that percentage or whatever. I can't remember now if it's 15% or 30%, but I think I've written it down somewhere in one of the slides. But that's to answer your question about the seatbelts. So they look for every way, remember, to how to reduce the claim.
Okay, thank you very much.
Okay.
Prof, how
Yeah?
do you help a foreigner who doesn't have a bank account?
Well, hello, you can continue.
Hello, Prof.
Yes, I can hear you. Sorry, it seemed to have lost connection again for a bit.
Yes.
Yeah.
How do you help a foreigner who doesn't have a bank account?
Foreigner who doesn't have a bank account. Geez,
Yeah, let's say Rapo
gosh. Yeah.
gave him
Um.
a million. Yeah, you got his.
Yeah. Yeah. So I think one of the forms actually asks for banking details, right? So I think you're going to have to try and make sure that your client gets a bank account. I know that currently, if you are illegally here, it is very difficult to try and get a bank account, but it's one of the things that I don't know the answer to. But if you're illegally here, then they'll say, but yeah, you're not entitled to any proceeds or you're not even entitled to claim. So we still got a year on that. But basically, I know for a fact that I've just helped a domestic worker, one of my neighbors, get a bank account. I went there to Nedbank and had a fight with them, and they made sure that they opened the bank account for the person. They got to make sure they provide their ID, etc. But yeah, that's things to do with the bank that you can sort out.
Okay.
Hi, Prof. Good evening.
Good evening.
My name's Richard. I just want to check with you in terms of the road accident fund and personal injury claims. I don't know, maybe we will still get to there or not. Is public transport covered
Yeah,
under
it
the
is.
road accident fund?
Yeah,
That's
yeah, it is. So if we're looking at maybe like a Patco bus that's conveying passengers, yeah, basically it does. It's such a general act, it covers everybody. And that's why there's this correlation, or they keep checking, there's an interaction between other acts as well, like the Defence Act or COID Act. But it does apply.
okay. So for example, if you look at public transport, when you need to transport members of the public, you need to have a PRDP. Okay. Now, what if the driver does not have a PRDP or a valid driver's license? Are the passengers still entitled to claim in terms of the RAF? Thanks.
Yeah, as far as I know, the passengers are innocent victims. Remember, they wouldn't actually know. They are the ones that are the innocent victims in this. They are entitled to claim, especially if it's public transport. There might be internal issues that then apply, but the passenger is innocent to that. Does that make sense?
Yeah, thanks, Prof.
Yeah. Okay, nice, interesting questions, colleagues. Because I'm going to carry on. Yeah?
Prof, you're speaking to Bunolo, and I would like to ask, what if the passenger or the pedestrian was in the wrong? Like, for example, if an accident occurred in the freeway, what happens then? Can the pedestrian still claim?
Lovely question. Colleagues, what do you think?
Yes, I think they can claim, but it will be apportioned.
Nice. So yes, to answer your question, my dear, remember on the freeway, you're not really supposed to have people walking across. The driver, it comes under the duties and responsibility of the
I can't hear
driver.
you. I can't hear you, Nontobeko.
Oh, sorry. I said that you can claim, but it will be apportioned. They will apportion the payout to the
Yes.
extent of your negligence.
Yes, that was a beautiful answer. So it will come down to the reasonable person test. Remember, they will look at the duties of the driver. They will also look at duties of a pedestrian. They also supposed to check. And remember, it's a freeway, which places more of an onerous duty on the pedestrian than it does on the driver. So yes, but it will be apportioned. It depends on the circumstances of the case, but apportionment would be applicable. She's absolutely right. Colleagues, any other questions before I continue?
If I may, I just want to ask about the quad motorcycle. Ne? You said is regarded as a vehicle. So if I'm in a private reserve game and I hurt myself, can I claim? That's number one. And also, I'm trying to think about the incident that happened at Bree. Especially the taxi drivers, because they were more involved. Who is at fault there? Because I mean, pedestrians and taxi drivers and people in the taxi were also hurt. Can they claim from REF? Thanks.
Okay, so with the quad motorcycle, remember I said that the idea of place or road is so wide. It's probably that it will qualify as a road or any place in terms of the act, because they even, like, I think one of the biggest examples was one of the big hospital chains. I think there was an accident that happened actually with a go-kart driver and a driver or something, or can't remember. I think it was a golf cart driver in a private parking lot. So even that game reserve, yeah, we haven't actually had a case with the game reserve, but I'm sure just based on other cases, it will probably qualify. But you never know. It can just get tested by the courts. And then your incident that you mentioned at Bree, that also is interesting. But there, I don't know if we'd qualify according to the Road Accident Fund, because was there really any driving involved? Was there conduct on part of drivers? That kind of thing. This was more like an explosion that caused the damage. It wasn't really accidents from vehicles. I don't know though if there's vehicles that went into each other, because then that might complicate it. But yeah, remember, we've got to go through the requirements of conduct, reasonable person test, negligence, all of that.
Okay,
Following?
thanks, Prof.
Yeah. Okay.
Yes, thank you.
Prof, sorry, I have one more question.
Okay, I'll take the one more question.
Okay, I now needed to understand, is it strictly attorneys that can claim on behalf of a person, or I can draft a power of attorney and someone, a regular person, can
No.
be my agent?
So that I'm going to actually deal with a little bit later on. It forms part of the relative exclusions, which is probably one of the next few slides. So maybe just hold that off and we'll give everybody the answer there.
Thank you.
Okay. Okay, colleagues, let me continue for a bit, and then somewhere we'll stop with questions again. Okay, so now in terms of exclusions, I'm going through different sections of the Act, if you can see. So we went through section 17. Now we want to deal with section 19. Now section 19 is exclusions. It's dealing with exclusions. So section 19, subsection A. This is the wrongdoer is not liable at common law, and it specifically applies to instances like statutory exclusions. So here I'm going to give this example of the COID Act, Section 35 in particular. And there was even a case, it was RAF versus Monyane. So in this particular case, if the employer is the driver and he's the cause of the accident, then you are the passenger or the pedestrian even, but you are the employee. So imagine the scenario of I'm driving in the car, I run a business, an electrician, and I employ Mr. Kumalo, and he's my passenger in the front seat there. And Mr. Kumalo, he's employed, and we also follow the provisions of the COID Act. We filled in everything. It applies to us basically. And I caused an accident. I don't know. I was not thinking too much, and I knocked into another vehicle or a lamppost or whatever the case may be. But in that scenario, the employee is not allowed to claim from the owner, the driver, first of all, the employer. And secondly, it then applies to the road accident fund, because if the wrongdoer is not liable at common law, then neither is the road accident fund. But that doesn't mean that's the end of everything, because basically the employer is going to claim from the COID Act. The situation is different though if there's co-employees. So in other words, my name is Mrs. Jack, and I've got Jill with me in the car, and we are both co-employees, and we're working for our electrician, and we're in the car, and I caused the accident. We are both employees. It's not a employer, not a boss worker situation. It's a, we are co-workers, in other words. So there's the exclusion won't apply. It specifically applies to the employer and employee situation. And there the act is very clear. You have to claim from the compensation commissioner. So that's your end route, compensation commissioner, basically. Then section 19, subsection B, Roman numeral 1. That scenario was a paying motorcycle passenger. That one has completely been rendered obsolete anyway. So even just scrap that from your notes. It's just not even applicable anymore. Continuing with this statutory exclusion, there's other examples of Just versus Score Supermarket. There, again, you cannot sue the employer because of the loss of the common law right in terms of Section 35 of the COID Act. So you don't sue the RAF, and that's because of Section 19, subsection A and 21. But as I said just now, your compensation you claim is from the compensation commissioner. One of the important things is, how do you know somebody is an employer and what is the meaning of employee? And there I've just mentioned, just look at your paragraph 14, because it kind of goes into a bit of detail. It actually, in a nice way, it explains it, but it's basically about the measure of control that the employee has over the employee. So it probably wouldn't apply for somebody who's working independently. But nevertheless, colleagues, just remember this. This is one of the most important ones in practice. So if you get it, you know, whoa, let me just check if an exclusion applies. What was the relationship between the two? Remember to check that. In the case of RAF versus Monyane, and in the case of Dladla versus RAF, it is somewhere in your practice manual as well. In this scenario, we have the employee, who was the pedestrian, and the employee was injured by his boss, the driver. It was confirmed that the employee does not have a claim against the RAF due to Section 19, read with Section 21, as well as Section 35 of the COID Act. So the employee can only claim against the compensation commissioner. And if the employee was injured by a co-employee, as I said to you, we are two co-workers, then the employee can still claim from the road accident fund. So I've repeated it a few times now, just so that it'll sink in there, colleagues. And I think somewhere I wrote an article, I can't remember, 2011, a while back, where I dealt with that case as well. It's not part of exams or anything. It's just for reading in your real life if you have some problem case that you need to figure out. Section 36, subsection 1A of COIDA. it provides for set off. So basically what happens, remember I said when it comes to state liability, you can't be double dipping or double compensation. So if another act is applicable and payment is normally the compensation commissioner gets paid out first. If you're not receiving information from them, you have to write to them and make sure they settle that claim, because that has to be set off from the road accident fund claim. And the rule is that you first apportion, so apportionment of damages acts applies. And then that gets deducted from the amount that's paid from the RF. So first of all, you find out what was paid out by the compensation commissioner, and then the apportionment applies and it gets deducted. Continuing with exclusions, colleagues, still on section 19. Remember I said there were some relative exclusions and some absolute. So the previous ones we just dealt with, they would be absolute exclusions. Like right from the beginning, if the employer caused the accident, you know it's excluded, can only claim from the compensation commissioner, and that's done with. But now these particular ones here, now subsection C, D, E, and F of 19, these ones are called relative exclusions in the sense that you can still remedy the situation. You can still rectify the situation. So this covers unauthorized handling of claims, agreements with unauthorized persons. Now, the lady asked me earlier on who is allowed to deal with these claims. So usually the attorneys deal with it. It was the bread and butter of many, many firms some time back. But other than that, it has to be the attorney or the third party themselves. So if they get an independent agent acting, the Road Accident Fund will just say, section 19D, for example, applies. Even an employee is not a third party. But I mean, sorry, not an employee, a supplier. A supplier is a hospital, Netcare or whatever, or a doctor. So they are not considered third parties. So basically, and this can still be remedied. So let's just say, for example, some other person decided to help somebody with their third party claim, and they're obviously not authorized because they're not an attorney and they're not a third party. Then you can still remedy it and still submit the claim and say, no, I'm the third party or whatever. Obviously, instances apply. I'm trying to think of a scenario where, I don't know, maybe you're dealing with a child that's lost its parents and has no family. Then you appoint a curator. So the curator then has the authority to step into the shoes of that client and then continue the claim. Or even it applies to someone who's in a vegetative state. They're in a coma even. There the curator applies. With regard to section 19E, they say if you fail or refuse to submit to a medical exam, or even if you fail to submit them with medical information that they need. So if they state to you during the course of the Road Accident Fund actual claim, let's just say it's even gone to litigation state now, and you are busy with quantification of the claim and you need to know what's your quantification for, let's say future loss of earnings. Let's just say in that scenario, you've given a report to say, a medical legal report to say, you've injured your arm, you are somewhat disabled, you cannot play the piano anymore, which was your earnings or your livelihood, basically. That was your job and it was your livelihood. Now you can't play the piano because your arm's been injured permanently. You've got actually a loss of function there in your arm. And then the Road Accident Fund said, no, but I don't know if I can agree with that 500,000 Rand claim for future loss of earning. I want you to please go to my medical expert, Mr. So-and-so, Dr. So-and-so. And in those cases, your client has to go for that medical exam. And if you fail or refuse, then they can say, okay, we're excluding your claim. But of course, remember, you can rectify it. And then 19F deals with failure or refusal to submit to the compulsory affidavit. That's like a compulsory affidavit. It's your stating affidavit where you explain how the accident happened, what's your claim for, etc. And also other statements that they might want. So again, relative exclusions from C to F that can be sorted out and rectified still, and then the claim can continue. Okay, this is a big one. 19G, and a really important one because it really changed the law. So from the 1st of August 2008, now we're talking about current legislation. Just to give you some background. So before the preceding legislation became applicable, so let's just say an accident happened in July 2008. There, if you suffered something simple, like you had an accident, you were a passenger, and you suffered a whiplash injury. Normally what you do is you go to the doctor, they would check maybe, you've got some soft tissue injury, you've got whiplash or whatever. This is going to give you some anti-inflammatories, etc. You might need to wear a neck brace for a little while, depending. But typically those claims, easily you could claim 12,000 Rand general damages for emotional damage, loss of this and amenities and whatever. You could have done that. So emotional shock, even you could have claimed for something as simple as a whiplash injury, you could claim 12,000 Rand for that. But since the amendment of the Act, that's any accident that's happened now from 1st of August 2008 onwards, this is an absolute exclusion. That if you're a secondary motor vehicle victim and you suffer emotional shock, you cannot claim that head of damage from the road accident fund anymore. And also you cannot claim it, in other words, you can claim from the wrongdoer driver, but that too, remember you're stepping into the shoes of the road accident victim. And there was a case of Bester versus Commercial Union, as well as Barnard versus Santam and RAF versus Sols. These ones here were really cases that dealt with emotional shock. And for example, I think the one case was two brothers crossing the road, where the one brother crossed the road and witnessed the other brother who was standing on the pavement. He witnessed his brother being knocked down and by a motor vehicle, and he suffered trauma, and that later on in his life severely affected for life, actually. But those are circumstances now where that emotional shock applied. Can somebody tell me what is the difference actually between primary emotional shock and secondary emotional shock? If you remember from your law of damages time, I think they used to really emphasize that.
Sorry, Prof, if I may give it a shot this side. If I remember correctly from yonder years ago, your primary emotional shock would be, as it was explained to me, you are the passenger sitting in the vehicle. You have, let's say, past trauma of your mother dying in a car crash while you were a baby. You are in the vehicle, there's a car accident, and you see the person next to you being decapitated. Apologies for the gruesome details. That would be first-hand emotional shock and trauma, or your primary emotional shock. Your secondary shock would be, for instance, where you are a viewer of the accident. So you're standing on the side of the road, you see a lady walking across the road, and out of the blue, two cars head bash each other, and you see her cleft in twain in the middle section, and you are traumatized by it. You're being haunted by nightmares and dreams. That would be secondary emotional shock, if I'm not mistaken.
Yeah, so you're right. So primary emotional shock is really where you are personally involved in things. You're there in the accident, even if you're a passenger, whatever, and you're there. But secondary is when you hear of something. So imagine a mother who's susceptible to heart attacks or heart problems. And she gets a phone call straight after the accident to say your son's died. That would be secondary emotional shock because she was not close to the incident. She just heard about it. She's a secondary victim, even though she's now had a heart attack from it. But yeah, she's a secondary victim. So anyway, the rule is that if you're a secondary victim, your claim is not against the RAF, but it's from the wrongdoer driver there in terms of common law. I think there was actually, yeah.
I just have a question. I know it's now excluded, but then what exactly were they claiming? Was it money that because I've been attending counseling?
Yeah,
I'm trying to. Okay, so it's because they've been spending money on counseling because they can't sleep.
Not only counseling. You remember, counseling will actually come under the heading of past hospital and medical expenses, or even future. Yeah. But this is actually just pure emotional shock. Like I'm traumatized, basically.
So I
Because
must get paid for being traumatized.
traumatized, yes. Yeah. I've written a number of articles, colleagues. This are Ahmed versus Steinberg. Again, this is for in practice. If you ever need help, always email me. But I've done a couple of articles on emotional shock. I've just done 2 actually. The one is been published in PAIR. It dealt with emotional shock, I think, in foreign law, and the one on South African law should be published later on this year. But I've just done a really nice sort of in-depth article on emotional shock, on the basic principles, that is. But it's not dealing with the road accident fund. It's just law of damages, more or less. It's
Sorry.
yeah.
Yes, it's again, Richard, Prof. I just want to go back to the COIDA, I just because that's a very interesting point for me, because your client might approach you on for RAF and it can come right to the RAF, and then the COIDA kicks in for example. And my thing there is because and I've been dealing with this on a couple of occasions, not couple of occasions, in numerous occasions, in where companies tender, for example. And part of the tender gatekeepers, the mandatory parts of it is you must have a letter of good standing from the Department of Labor for your COIDA, because that cost gets factored into the tender price, for example.
Yeah.
And what we should keep in mind is if your client cannot claim under RAF, but in terms of the from the compensation commission, we need to keep in mind is that any contract today, especially with government tenders, COIDA is covered the cost because the suppliers, they tender in the pricing.
Oh.
That costing. So, for example, they say they're going to have 100 employees on site for 5 years. That is basically covered in the tender price, because most of the gatekeepers today is if you do not have a letter of good standing in terms of COIDA, which is get issued by the Department of Labor, your tender becomes non-responsive.
Okay.
So my learned colleagues must just keep that in mind. Is not to tell your client to go away, but is to go look at, and that is where you can claim for your client that money, because if the tender was for 5 years or 10 years with the government department, it is being covered. He received that money, and they need to submit annually a COIDA letter of good standing. So I just want to say that to the colleagues. Yeah.
That is excellent. Thank you, Richard, for that information. Just jokes there for a minute. You know, at the moment, our colleagues are struggling to get their money from the road accident fund. Apparently, they're doing it in batches, and people are standing in queues from midnight. So maybe they're better off claiming that side there than the road accident fund. But okay, jokes aside, colleagues. Yeah, the road accident fund is really having trouble paying out claims at the moment. They have called it a state of emergency. I think the Law Society said it's a state of emergency. But really, thank you so much for that, Richard. It's really appreciated. Thank you.
You're welcome,
and
bro.
it makes absolute sense even. But that letter of good standing, and it's a continuous assessment yearly. It really makes sense. Okay, colleagues, let me check the time. Okay, how about okay, let's have a break now, because now we are going to go into info regarding hit and run claims, which is a new section of the work, and I think you could do with a break. So it's 5 to 7 if I'm correct. Shall we? You said you take a 15-minute break. Shall we get back at 7:10?
Perfect, Professor. Thank you very much.
Thank you, Professor. As the court pleases.
Okay, colleagues. See you soon. I'll see you soon. Let me just mute my mic.
Hi, Professor, are you there?
Yes, I am here.
Yeah, you're sharing your screen with us, and you have the right to privacy, eh?
I know. I'm
Yeah.
actually just checking the chat box, so it's still within the. It's
No,
still
cool.
within. Yeah.
Yeah.
No, but thank you for that. Yeah.
Be
Thanks.
warned, Big Brother's watching.
Thank you there, Richard. Thanks.
Hmm? Sure, sure. Hey, ore. Ma? Ma? Hey, ligay. Hey, Mkoni. Hey, kilala
Ladies
po
and
yung
gentlemen,
network ikaw.
mic check, please. Mic check,
mute,
please.
please.
Breaking news, criminals driving a quantum minibus and a blue BMW approach Javelin police station. Food lovers.
They did not manage to rob it.
Well. Yeah.
I'm smoking a
May, your mic is on.
Oh, sorry.
No, man. Now continue. Leave the mic on, man.
Sorry, guys.
We're hearing about the quantums.
Yeah, there was a robbery at Jablani Mall yesterday. So showing my mom the facts that it's now reported. She was involved. Well, not involved. She was there.
Oh, okay, she was a witness.
Well, she was in the shop that was getting robbed. So, yeah.
You said she was involved.
No.
Does she
She's not
need an
involved. She was
attorney?
not.
Does she
We
need
do
an
not own
attorney?
any rifles at my house. I just want to make that very clear. We're a gun-free zone. She
Okay.
was at the store that was being robbed, and they all had to take for cover and. So
Mommy
that's how.
was involved. Bottom
Mama,
line.
Mom, I can put you
Mommy
under
was
witness protection.
involved.
I can get you into witness protection immediately.
Go to claim.
Mommy
She says she's
was
gonna claim. I
involved.
don't know from where. What emotional damages? Okay, I'll find out if Road Accident Fund can help with that.
Very emotional.
Trauma.
Trauma, guys. Trauma.
Should we sue them all? Should we sue them all?
We should sue them all. Okay, thank you, Richard. I will take that on note, my learned colleague, and we shall revert.
Hi, colleagues. Just catching on there at the end. Are you all back? You all ready for the marathon of slides?
Indeed.
Yes, Prof.
Yes, we
Yeah.
are, Prof.
Nice when you're this enthusiastic. I love it.
Let's go.
Yeah. Okay, colleagues, let me get this PowerPoint presentation up. From current slide. Okay, we were here. Okay, we're doing well with time so far. Now I want to speak about, so we're going back to section 17 now. General requirements. And now I want to just talk about hit and run claims. I didn't want to confuse you in the beginning. So everything that applied before, that's still applicable, but now certain things might be restricted because it's hit and run claims. So first of all, there was a regulation, I think it was Regulation 2 that was published with the amendments. So it deals with the current legislation, and that Regulation 2 basically said, if you want to claim from the Road Accident Fund, first of all, there must be compliance with the Act, which is very general, broad provision. Then they stated there must be unlawful and negligent driving by an unidentified motor vehicle. Now, when we talk about unidentified, it's the owner or the wrongdoer driver that we don't know. So even if you might know the make of the car and the description and the number plate, etc., that doesn't actually mean you found out who's the owner or the driver. Remember, with time periods, things can change. A driver can be a driver or registered owner at this period of time, and then another period of time, it's a different driver. I know this for a fact, a very big lesson I learned with my very first trial, where I thought I was a hotshot attorney there, and oh, you're not a driver because at the time, who was driving the vehicle, etc. We did a whole case, and it turned out that we didn't actually know who was the owner or driver, because at the time it was registered to somebody else. So anyway, colleagues, this is really important. So how you figure it out whether it's unidentified, it's really that you don't know the owner or the driver of the vehicle, right? Then the other point of the regulation, let me just minimize this here. You can see the screen clearly. Was there must have been bodily injury or death caused by the unidentified motor vehicle. So there we go. Either the person died or there was injury or harm sustained. Bodily injury though. The rest of the requirements in terms of Regulation 2. Oh yes, actually this slide here deals with sections that applied in the preceding legislation that was then scrapped. So according to the preceding legislation, and now you can actually see why they scrapped it, because one of the requirements is you had to take reasonable steps to identify the identity of the owner or driver. There you had to either go and say, I've done a search, I've checked the SAPS, and maybe even have to write an affidavit stating all the steps you've taken. So that they scrapped because it was very tedious to comply with. And the second one was reporting of the accident within 14 days. That caused many issues because we had people that were injured and they couldn't get to report to the accident in time. 14 days had passed, so that was scrapped, thank goodness. The next one was physical contact. So they said that previous cases, there had to be physical contact, whether it was between the vehicle and the pedestrian, or a vehicle between a vehicle, or contact with something. And then they scrapped that completely, because imagine a scenario where you're a driver, you're trying to avoid this loose rogue tire that's come on the road, and you actually just swerve, and let's say that you don't actually make physical contact, but from braking very hard, your passengers got severe whiplash injury. So anyway, suffice it to say, they scrapped the requirement of physical contact, and then they also scrapped the requirement of certificate probabilis causa, which was just to state that the person's been practicing for 10 years or so. Anyway, that has been scrapped. It's just for noting there, colleagues. Hit and run claims. Let's focus on the current legislation. So all claims arising out of motor vehicle accidents, and I'm going to repeat it so you'll never ever forget it, after the 1st of August 2008. So you don't need to comply with the requirements on that previous slide. Remember, it's scrapped only for noting. In terms of the amendments, an unidentified claim must basically comply with section 17(1), subsection A and B. And here's the important part. It must be lodged within a period of 2 years from date of cause of action. Now, there can be 2 dates of cause of action. I'm going to get into that just now. But just remember, date of cause of action. 2 years from date of cause of action. And I'm also going to explain how you calculate that. Once the claim is lodged, the period is then extended for the further period of 3 years. So imagine this, hit and run claim. You have got 2 years within which you must lodge the claim with the road accident fund. So you've got 2 years. The moment it's lodged and it's been lodged and they've obviously received it, then you now your period has now extended to a further 3 years, and that 3 years is now to basically issue summons. So if it carries on for 4 years, 4 years or 5 years minus 1 day short, it's still fine to even issue your summons there. So anyway, that's just basic prescription periods. So the Prescription Act does not apply to road accident fund claims. You know, the Prescription Act, most of the things the claim prescribes within if you don't lodge anything with 3 years, after 3 years it's expired. So in this case, the road accident fund has its own prescription periods, and there's different periods that apply to hit and run and to identified claims. Remember in the beginning I said you get 2 types of claim. You get the identified claim and the unidentified claim. Right. Okay, so it will always be a factual question I've written here as to who the owner or driver is. Sometimes in practice, what happens is, excuse me, colleagues, sometimes what happens is you think it's unidentified and then later it becomes identified, or the other way around. You think it's identified and actually it's not identified because you don't know who the owner or driver is on that particular date of the incident. So if you're not sure, it's always safer to lodge it as a hit and run within that 2-year period. So lodge it within that 2-year period. Then at least you know you're safe. If it turns out for some reason, and this I mean now after the fact, you've checked everything after 2 years, and it turns out it is a hit and run, and you go and lodge the claim after 2 years, the road accident fund is going to reply to you very nicely. The claim has expired. So one of the things they want to warn you about, please make sure about this and make sure you comply with that hit and run time period. I think there's a hit and run checklist. I hope it's still on paragraph 7.7. I think it should be right. I have rectified the paragraphs for this year's notes. So here's a little slide here where I'm going to show you just the difference between identified claims and unidentified claims. So if it's, remember the second one down here under red, unidentified claims, I've said to you 2 years within which to lodge, and then it automatically gets extended to 3 years. So in other words, it equals to a total of 5 years. And that total of 5 years is the time period you have in which to issue and serve that summons. So I've already explained unidentified claims. Now let's look at identified claims. There, it's the opposite. You actually have 3 years within which to lodge, and then it gets extended to 2 years, and then your total is still 5 years. Okay, hopefully, colleagues, you have this. You're understanding? Are you following?
Loud and clear, Prof. Loud and clear.
Yes, ma'am.
Okay, great. Right, issuing and servicing of summons, it basically suspends the subscription. So it holds it in abeyance, if you could say. Remember I said earlier, there's 2 different causes of actions that might be applicable. So the first cause of action is date of the accident. Now that applies specifically to certain types of damages. So it's just a natural thing that the date of the accident is the cause of action for hospital and medical bills, as well as loss of earnings, as well as general damages, right? Because you're personally involved in the accident, for example, and you needed to go to the hospital, to doctors, and also you haven't been at work. You might also not be at work in the future for some time, and you've suffered some emotional harm, trauma, etc. So that's your date of accident, is your date of cause of action. The second cause of action period is date of death. And there we're looking at cases where the breadwinner has died or the breadwinner has been injured and you are claiming loss of maintenance. So loss of maintenance is basically the cause of action there, date of death. So you'll take the date of death, the date the person passed away. Now, here's an interesting one. When it comes to minors, right? Anyone that's under 18 years old, basically. And here, minors are treated differently when it comes to hit and run and identified claims. So with identified claims, the minors, they have 3 years within which to lodge after attainment of majority. So after they turn 18, depending on their date of birth, so whenever they turn their 18th birthday, they have 3 years within which to lodge. And that is now extended for 2 more years to equal a total of 5. That's to issue and lodge your, to lodge and issue that summons, to issue and serve that summons. So with unidentified claims, here we're talking about hit and run, minors, right? They have 2 years from date of cause of action, extended to 3. What does that mean, colleagues? Before I show you the next slide, let's see if somebody can pick this big thing up.
Prof, if I may have a gander at it.
Yeah.
So with the identified claims, the 3 years to lodge after attainment of majority, that means that on the day you turn 18, prescription starts to run in, well, if we can call it that, prescription in air quotations, starts to run from the day you turn 18, 3 years later on, claim prescribes. That is after you have attained the age of majority, aka 18. However, with unidentified claims, you have 2 years from date of cause of action, which means that 2 years from the day the accident happened, then you need to institute it, which can be then extended to 3 years. So the main difference is when you turn 18 versus when the cause of action happened. However, I have one question with the identified claim. I come from a medical malpractice background.
Yeah.
Now, the way prescription works there was prescription starts to run 1 year after the attainment of majority. Now, I'm not certain if that's also applicable here because I know the RAF works differently to prescription.
Yeah.
But is that also applicable here, or is it 3 years after
No.
attainment of majority?
So it's not applicable. In other words, you have to follow the prescription that's in the statute itself. And it's really set out in section 23 of the Act. And there it specifically states, yeah, it covers minors have 3 years, they once attaining majority, they have 3 years. This is important to lodge the claim. That means like to start your claim off, lodge it with the road accident fund to say, I've done my investigation, here's my affidavit, here's my supporting documents, here's my claim form, here's maybe reports from doctors, I'm lodging this claim, my client was involved in an accident this time, he has a claim, locus standi, everything is complied with, basically. That's to actually lodge with the road accident fund. So you have 3 years within which to do that, right? Then once that's complied with, then you have a total of 5 years within which to issue and serve a summons. Now remember, that's now starting a litigation process, because there's a possibility that if you lodge within this time period, they might actually settle, or they might actually give an offer and say, okay, we want to settle on this. Our driver, the wrongdoer driver, was definitely at fault, 100% negligent. We're conceding the merits, and we're giving you this offer for special damages or whatever the case is. So that's, but your actual differentiation you made stating that with identified claims, we look at the age of majority, but unidentified, you're absolutely right. You look at the date of the accident. So it's like as if that legal disability is done away with when it comes to minors.
Thank you very much, Prof.
Sorry, Professor, I just want to add on to what, or just get clarity on what Janus has asked and stated. In the normal prescription, you get interrupted and uninterrupted. In terms of Section 23 of the RAF Act, is that applicable, the interrupted and uninterrupted part of
Yes, so I think what you're talking about is interruption basically takes place the moment you issue a summons. So let's say you within your 5-year period, whether it's identified or unidentified, you have lodged and you have issued summons. Now, at the moment you issue summons, whenever you do that, it's interrupted in the sense that now prescription stops there. It's interrupted in that sense, because sometimes cases can go on, I'm not lying, for over 10 years with the road accident fund. So it gets interrupted at that stage, if we could say it in terms of understanding, yeah.
Yeah, okay. And
If I may
civil
ask,
law.
with regards
Yeah,
to now
thanks.
calculation, with regards to the calculation of the days, right?
Yes.
I read there's 1 in, 1 out, or is the first day of the incident, or does the first day start 24 hours later?
So, okay, we're going to get to that particular way. So the first day is included and the last day is excluded. But we're going to do an example here now. I just said that I said in note here, Gabuza versus RAF. This was an important one in the sense that the 5-year period ends on a day in which is not a court day, or if the road accident fund was closed, for example, in that you couldn't lodge or you couldn't issue. So it had to be a normal court day. So even if you're calculating, so we're going to do an exercise here. We're going to calculate what is the date, the last date to lodge and the last date to serve. And let's just say that that particular date, I haven't actually, I think we did actually check in the last semester, but that fell on a normal court date, was fine. But let's just say that your date works out to a day that is calculated on a Saturday. Then you know that you can actually serve it on the Monday or lodge it on the Monday. So that was one of the important cases that clarified that for the legal practitioners. Following on from that, let's just do the simple exercise. The date of the accident is the 2nd of September 1998. I want you to please take a minute and figure out what would be the date of lodging the claim, the date of serving the summons for identified and unidentified. And also tell me what would happen with the minors in both instances. I will give you a minute, literally counting till 7:30.
Yes.
Like somebody's mic is on there. There's little kids in the background. Okay, colleagues. Anyone want to take a stab at it? Let's start with the identified claim. Give it a stab. Anyone?
Okay. It's not Tobago.
Okay.
Okay, with the identified claims, it would have to be within 3 years. You'd have to lodge the claim within 3 years and then serve the summons within 2 years.
Right.
And are you then asking that we also specify the dates, like of the specific
Yes.
date?
Yes.
Okay, I think with that, because you said you count the first day and don't count the last day, then the last day to lodge would be the 1st of September.
Brilliant. Yeah.
Let me see, 98. Okay, the other year.
What's the yeah?
98, 2000. So the 1st of September 2000.
2001, right?
2001, yeah.
You're dealing with identified, so it's 3 years. So lodging claim, you were right. You got the date right, 1st of September 2021. No, 2001, sorry.
2001.
Yeah, 2001.
Yeah.
So that's a Saturday, ma'am.
Okay, so if it's a Saturday, then it's going to be on
The
you're
3rd
going
of
to have until
September.
Monday. Yeah, you have until Monday. I thought we went back. Somebody went back for me last semester and they checked the date and they said it fell within a court date, but I will take it as
Unless
it.
there's a leap year in those years, then it means. Yeah, but what's the likelihood of having 2 leap years in a space of 3 years? So it's either a Saturday or a Sunday if there is a leap year. But it definitely, it's not a Monday. It's not a court day.
Okay, I'm going to take your word for it there. But basically, the way she calculated the date was perfect. It's the 1st of September, 2001 in which to lodge, and then what date to serve summons. Colleagues, did you all get that?
Yes.
Yeah? You all following?
Yes.
Yes.
Following, Prof.
All right. So somebody else tell me what's your dates for the unidentified claim?
I'll have a stab at it if you don't mind, Prof.
Go for it.
So in the unidentified claim, that would be you need to lodge your claim. Your last date to lodge would be the 1st of September 2000, and you need to issue your summons by no later than the 1st of September 2003.
Perfect. And then tell me, colleagues, what happens in the case of the minor for the unidentified claim first, because that one's easy.
Prof, yes, in terms of the unidentified claim, the same as the unidentified claim for it's the standard procedure. So you have 2 years from the date of accident, so 1st of September 2000, and then a further 3 years to serve your summons. So then once again, it would be the 1st of September 2003.
Perfect. And then colleagues, what would be somebody else give a stab at identified claim for the minor?
How old is the minor?
Good question. So let's just give the minor a birthday. Shall we say 1st of April? 1st of April. We've got to make it 1990. So this person would be 8 years old, basically. 1990.
2008. 2008.
We're going to need a calculator now.
Prof, we studied law for the words. We didn't
Yeah.
study it for the mathematics.
Okay, so anyway, the basic answer is the moment the child turns 18 years old, your prescription starts to run on the date of the birthday. So with an unidentified claim, remember the 2 years period applies from the date of accident, but in identified claims is the date of the birthday, the date of attaining majority. From that day, 3 years within which to lodge, extended to 5 before you actually start litigation and you start with the issuing and servicing of summons. Yeah. I'm very pleased, colleagues. Thank you. You really are listening and following. Now to complicate and confuse you, although you should only note this because it's really not applicable right now. So much time has passed. So remember the age of majority changed at a particular date in time for South Africa. We went from 21 years old to 18 in a blink of an eye. And the applicable date there was from 1st of July 2007. So just for noting, prescription will be suspended and only commence to run from the date in which the minor turns 21. So that happened if anything happened before the 1st of July 2007. But if the cause of action arose after 1st of July 2007, then we just comply with the age of majority that was applicable at the time, which is 18 years old. All following. I just have to point these weird things out. Following, colleagues?
Following. Yes,
Great.
ma'am.
All right. Practical aspects. Paragraph 6.2.3. So normally the claim of the minor is brought on behalf of the minor by his guardian. Now this section is really important, colleagues, because it's particularly important when you're drafting particulars of claim or any kind of pleadings, right? When you're lodging the claim on behalf of a child, you have to act sometimes in two capacities. So the parent can act in a capacity in a representative capacity as well as in a personal capacity. Before reading the slide, why would a person or a parent act in a personal capacity? For what kinds of damages? Why in a personal capacity would the parent be claiming damages?
Sorry, Prof, please repeat the question.
So my question is, let's just say a minor, I've got my son, he's let's just say he's 9 years old, 10 years old, turning 10. He's involved in an accident. I was not there. But we need to actually get this court process going. We need to lodge the claim with the Road Accident Fund #1 before we start litigation. And my son has got a lot of expenses. I've taken him to the hospitals. He was in hospital for a month. He's seen number of doctors, number of specialists. He's seen therapists. In the future, he has to go for another operation. His dream in life was to be Olympic gold medalist swimmer. His leg is damaged to such an extent that the doctors are actually saying that we don't know if this is going to be a true career for him going in future. Now, as a parent, I'm sitting with this child and all these bills that I have to pay, all these things to take into account for the past and the future. As a parent, now you also as the attorney, when you're drafting your particulars of claim, you are going to have to cite your client in two capacities. So it will be the plaintiff. Colleague, sorry, someone's mic is on.
Gabelo?
Colleagues? Okay. Someone's mic is still on.
Gabelo, please mute.
Thank you, colleagues. I see it's gone quiet again now. So there's my issue. Now, in what capacities would you be claiming these different heads of damages?
Oh, I think, Prof, I think that like the first capacity would be as the natural parent of the minor. And then the second one, it's in your capacity, but claiming for the money. I'm not sure how to phrase it. I'm not sure if I could say personal interest, but rather that your personal loss that you incurred to pay out whilst you were still waiting for RAF to pay.
Yeah, so I think more or less you've got the idea. So basically, when you're drafting this particulars of claim and you need to state your plaintiffs in two capacities, you'll state mother, whatever, in a personal capacity, and then also in a representative capacity on behalf of the minor child X. And the reason why you do that is because later on, when you draft your paragraph of damages, you will say the plaintiff in a personal capacity following damages. Now, in the personal capacity, remember as a parent, you paying the hospital bills because the child is not earning any money. So you paying all the hospital bills. The past, you're probably going to pay quite a bit of the future. So you can even claim on that. But in a representative capacity now, you will claim the general damages for the child as well as the future loss of earnings, because we don't know the future loss of earnings for the child. So they just to remember this difference, right? That you will be, the parent can claim in these two capacities, and when you have your heads of damages, you break it down. I think it is actually in your notes somewhere. You know, in those examples they give you, it's stated so nicely in personal and representative capacity. But a lot of the times in your assignments that I've seen, this is a very big differentiation that you need to make. And you need to also follow that through when you're claiming the damages. In that paragraph, you've got to state plaintiff in personal capacity, damages XYZ, plaintiff in representative capacity, XYZ damages. Are you following that, colleagues?
Yes,
Prof,
Prof, I've got a question.
Yeah.
Same here, but
So
Bila, go first.
Okay, we'll let the lady go first
Of
and
course.
then the gentleman.
So I've worked for a law firm in 2018 that does RAF, and with these minor claims, they would just claim in the representative capacity, but still claim in that particular representative claim the past and the future. So how does that work if you're saying that we need to claim twice in the personal and the representative?
Because the parent, okay, so you can actually draft two different summons. You can draft a summons where it's just the parent, him or herself, and there they're claiming for hospital expenses, etc. And then you can draft a separate summons where it's the child, where the parent is obviously duly assisting the child, and then that's for the child's general damages or loss of earnings. So that is a possibility to draft two different summons. It's extremely tedious to do it that way. So the easier way is to have one summons, but then the plaintiff or the parent is in the plaintiff in two capacities, and then later on, when you're drafting the paragraph on damages, you split it up there. But to be fair, there's nothing wrong in having two different summonses actually. But yeah, it can get a bit tedious, if I could say it that way. Does that make sense?
Yes, it does. Thank you, Prof.
Yeah. Okay. Yes, and then the gentleman, sorry, I cannot see your names because I'm looking at the exact same screen you're looking at there.
It's Johannes, Professor. No, it's just a point on technicality. So let's say, for instance, you do the parent in the personal capacity and the representative capacity. When your claim is successful, I know, but is usually the case is that the children's, if I can call it, share of the damages gets paid over into a trust with a trustee there too. So on the payment, on the whole payment thing, if you represent your client in their personal capacity, they can claim personally their share of what they are claiming for, but the child share is paid then into a trust account, preferably with a trustee they're with. Is that how it works, or is it more like
Yes.
you take all the fund into a trust and that's that?
No, you are absolutely right. Because the parent is in a personal capacity already paid for the hospital and medical expenses, they are entitled to get it paid into their bank account, for example. But then with the child, yes, remember it goes through the trust and the attorneys because it must be dealt with. It's still future stuff. And even general damages, it's an unquantified claim. And yeah, but you are right. With the parent, can you see it makes absolute sense? I'm the
Yes.
parent, I already paid those bills and I should be entitled to that money. With future medical costs, right? Maybe the parent still has to pay that. But what happens there is you don't get an amount of money that's paid into the parent's account, for example. What actually happens is you get a letter it's an undertaking to state, yes, we acknowledge that the minor X is entitled to undergo surgery when the child turns 12, to put in a plate or a screw, etc., and further occupational therapy, etc. But we undertake to pay those bills, or 80% of the bill, or 100% of the bill, or whatever. So it's an undertaking. So for future medical payouts, it's literally an undertaking that they will undertake to pay that in the future. So the past medical expenses, they get paid to the parent, basically. So yeah, just on that technicality, you are right. Yeah.
Thank you very much, Prof.
Yeah.
Prof.
Yeah.
On what Giannis actually asked, so I've also seen attorneys actually, you know how we'll say the money must be in a trust because it's for a minor and all of that. But I've seen attorneys actually give the parents the money. Is it because there's a trust to say, you know, they won't probably misuse the funds? How does it go about that? Or are they giving them a portion? How does it work where you actually give the mother of the child the money and not open a trust account?
So for the future loss of earnings, there is an amount that gets paid, and it can be paid to the parent as well. But I think there's like strict rules on how it gets applied. And another thing is that it's never so straightforward that, okay, there's a 200,000 Rand lump sum for the future loss of earnings, because in those calculations, my goodness, you're going to have actuarials calculated, you're going to have the medical legal reports are going to be 20, 30 pages. Luckily, we don't have to calculate. The actuarials do that. And they take all these contingencies into account. If you remember from law of damages, it's such a complicated thing dealing with contingencies on its own even. You remember?
Yes.
Yeah. But yes, colleagues, money that's in trust for the child is for the future of the child, especially with loss of earning, must be kept within like trust monies, in other words. And they might be strict on how that is worked out. But that is the general rule. It's like basically must be put in trust, because can you imagine the abuse that can apply? It's for the child's future and the parents squandered it all on a brand new car.
Yeah. Advocate, I just want to, or Professor, I just want to add to what you're saying, and I did post a case early
Okay,
on
great.
on
Yeah, I
the
saw it.
yeah, the Sapil matter versus Judge Heath, now as the Special Investigating Unit. And that case speaks volumes on just what you've said.
Okay.
And
Colleagues,
that was part of the proclamation then.
Colleagues, definitely worth reading that case. Definitely worth it. I think it is also mentioned in the practice manual. Am I right? It is there.
Yes, and Lerato always wanted to know where I work and what I do. Lerato, I work for the SIU.
Okay, thank you for that, colleagues.
Sorry, ma'am, before you go ahead, I just have hi, can you hear me?
Yeah, I can hear you.
Okay, it's Kwanele here. I just have a question. We spoke about the possibility of issuing two summonses, one on the representative capacity and one on the personal capacity, or just issuing one summons and then like being clear on the particulars of claim. wouldn't it be more profitable for the attorney to do two summonses? Yes. Because I mean that there are
It would-
limitations,
it
right?
would, but-
Especially if it's on the contingency fee.
No comment.
No comment, yeah. No, I understand where you're coming from, but to be honest, I haven't ever seen in practice where they have split it up. But now there's a lady that did tell us that it's been done. So you never know. From what I know, I mean, logically, it's just one summons. You don't want to complicate it any further. You have one summons number and it's done with, but you're dealing with one thing. Because now you have to have a summons with the same, it will be the same summons number, but now you claiming now something differently in a different capacity. So I've never seen it split up, but technically there's nothing wrong with having it separated in that way, especially since the lady said she's seen it in practice now.
We need to be careful of double dipping.
No, they will pick it up though. They will definitely pick it up, and it will be having one number as well. Yeah, they'll pick it up. But well,
that's
colleagues,
disappointing.
I'm enjoying the interaction here. It's good. It's questions that are absolutely relevant. So that's really great. And even with the information you're giving, perfect. And then,
Professor, sorry,
yeah,
sorry to interject you. This is such a
Yeah.
good lecture. I just wanted to ask a question regarding this, the parent in personal capacity. Let me just give a hypothetical situation. A kid gets knocked out by a car and then they suffer injuries. And the parent goes and claims to the RAF in their personal capacity as the parent for the current expenses, medical expenses, and for the future expenses, and then they therefore claim on behalf of the kid.
Yeah.
So what happens to the claim? Because I have an understanding that RAF does pay. Let's say the kid now dies from an unrelated cause, which wasn't the result of the accident. Maybe they drowned or something like that.
Yeah.
Can the RAF therefore pay for future medical expenses which were not incurred as yet? And how is that assessment going to be made? Because I have an understanding that they do pay even when the person actually died from succumbing to the injuries from the accident. So I just wanted to just get that.
So they will just do an undertaking for future stuff. They love to do undertakings, right? Which means they're not going to give the money out now, but they're undertaking to pay it at a later stage. Or sometimes they even do things in installments, but that's always when merits are conceded. You've conceded 100% liability on the part of the wrongdoer driver. You can pay out in installments, and then you can also do an undertaking. But an undertaking is like, they love it. That's the first standard thing they do. It's an undertaking to pay out in the future. So they won't even pay out for the expenses that accrue later on. But in this instance now where the child has died, obviously foreseeing that some things like this might come across exactly like how you've explained it, where the child's actually died now, let's just say that future operation, the child is no longer needing that operation, cannot go for it. So then that basically falls away.
Okay, no, thank you so much, Professor.
Yeah.
So
And
can
then-
I make a comment?
Yeah.
Sorry about that. I just wanted to say one of the colleagues was asking about the whole, even the gentleman that just asked about what happens in terms of, the child and the mother and how they look after the money. So I worked as a fiduciary specialist for about 18 years, right? And what normally happens is you have to establish a trust. So the RAF, as soon as your case is won, they establish a trust, and those trusts are called court order trusts, and it depends obviously on how you actually got the claim. Some of them are medical claims, some of them are RAF claims. But what normally happens when you are appointed as a trustee, you have a fiduciary responsibility of ensuring that the expenses are not claimed by the parent. But obviously parents, oftentimes I've seen in my career that parents do take chances. And remember, you can't necessarily refuse because they always make an excuse. Like some parents, when the child is badly injured, they would want to extend their homes.
they would want to, you know, so
Other expenses not related actually
Yes.
to the child. Yeah.
and also later, in terms of the medical claims later, depending on the type of injuries that the child has, you speaking about that undertaking, they do you know, confirm that they'd pay later, but you must still send proof,
Follow
you know,
up.
and
Yeah.
it's a whole claim altogether. That's what I just wanted to speak
That
to.
is so lovely. Thank you for giving us that info, colleagues. Amazing how you mentioned, especially about the fiduciary duty, colleagues. It's so important about that fiduciary, even though it's not in your notes. She's explained it so well. Thank you for that, my dear.
Thank you, Professor.
Okay.
Sorry,
And then-
Professor, sorry, quick. I just, and
Professor?
very, very, very important what my learned
Yeah?
colleague has said on also is, there's a very interesting case, Dube,
Yeah.
versus Road
Yes.
Accident Fund
Yes.
of 2014. And it speaks
Yeah.
about minors and guardians and all
Yeah.
of that stuff.
Yes.
Well done.
Yes.
Well done, my learned colleague.
Yes, Dube is in your
Thanks,
notes as
Richard.
well. Yeah, it's in your notes, colleagues.
Professor, can I just also say something? There's that new matter, the one for early this year for Eastern Cape, where they have made a decision that they are going to stop paying future medical expenses to attorneys, and they will have to put claims directly to the department, and they'll pay directly to the service provider based on those other fraudulent claims that were happening in Eastern Cape. I think the case, it was TN. I'll check on the
Put it in
case
the
and I'll
link.
just put it
Okay.
on the link.
Perfect. Thank you, colleagues. Dealing on this also, colleagues, there was a point in time where the RAF actually said they issued some directive, and they stated that they no longer want to pay the suppliers, like for all the hospital bills, etc. So I think Discovery has taken them to court now. And I think it's also being the lead is also on top of it. I think they sent out a circular to the attorneys as well. So yeah, just keep your ear out for that, because we've still got to hear what they're doing there with Discovery, and that will obviously apply to all suppliers. So just keep your ear out. A lot going on at the moment, colleagues. But yeah, share the knowledge always. Brilliant. Thank you. Following on for that, colleagues, I'll carry on with the slide now. If a breadwinner dies on impact, in other words, dies at the scene of the accident there and there, can the dependents claim, or now it will fall onto the estate, right? And the dependents, obviously. But can you actually just claim general damages? General damages is pain and suffering, emotional shock on behalf of the deceased, the dead person. Anyone want to take a stab? You don't need to feel shy.
I think I'm gonna go here for the long run.
Okay.
Maybe loss of support, because general damages. Yeah, I'm not sure. Yeah.
Yeah.
Professor, if I might take the long run here.
Go for it.
What if the breadwinner or the married couple was married in terms of customary law, out of community of property, antenuptial, or a living spouse?
Okay, so I'm going to deal with that. Yeah. So I'm going to deal with that very soon. That's our next section of the works. I'm going to hold you off until there. Good question. It means your mind is working already. You're talking about locus standi there. But just in terms of general damages, remember when the person dies on impact, they didn't actually suffer any pain and suffering. There's no emotional shock. But there might be emotional shock that can be claimed from the secondary victims, the person that hears about the accident, right? But remember now, the Road Accident Fund has excluded claims for secondary emotional shock. Just something to bear in mind, always. Next slide is suspension of prescription. So where a person is legally disqualified, in other words, they lack the locus standi, or let's just say they are considered or declared insane. the claim of that disqualified person doesn't prescribe for as long as that disqualification applies. And that relates to certain categories of person. The first one we already dealt with at length is the minors. So it applies to mentally ill persons or mentally incapacitated persons. Forgive me if I use the incorrect terminology, because nowadays you have to be so careful on how you state these things, and persons under curatorship. So basically, suspension of prescription applies to these category of persons, and it makes absolute sense because they don't have the full legal capacity, if you could put it that way. There's limited capacity there. Prescription does not run against a permanently unconscious person or a person that's in a vegetative state, and that actually applied only very recently in our law in the case of Malloy, and that's mentioned in the paragraph 6.2.3b. Remember, hit and run prescription is not suspended. Remember, especially with our minors. With the others, if they are mentally ill or under curatorship, remember a curator is appointed to stand in their place, and then everything may continue. Right. So we've gone up to the stage where we spoke about how you lodge a claim. Now we want to speak about the actual issuing of the summons. Now the summons may be issued and served, and the Act says after compliance with section 24(6), subsection A and B. Now, basically what that means is that you've lodged a claim, right? Let's just say you did it on Monday, and you haven't heard back from the RAF, and a time period has passed by, and you need to know, can you issue summons? So there the statute actually says, before you issue summons, you must wait 120 days. You have to give the fund 120 days within which to consider your claim. Give them a chance to gather the papers, read through it, etc. And you're going to laugh, but 99% of the times, 120 days passes and they won't even respond to you. But after that period of time, you are allowed to issue summons. Sometimes it might happen that after say they've received the claims, somebody assessed it and the assessor has looked at it, and after 60 days, the assessor replies and says, sorry, we are denying any liability, or whatever the case may be. If that happens, in other words, if the RAF repudiates the claims before the 120 days passes, then you may serve summons. Now the question is, how do you calculate those 120 days? And it's specific. You include the first day, exclude the last day, you disregard the Sundays and public holidays. So just like how we were calculating in the previous example, so here we're saying the same thing, but it's 120 days. So you physically got to go on the calendar, check the day when you issue the summons, and then you count your 120 days. You exclude, of course, disregard your public holidays and your Sundays. Yeah, Sundays and public holidays. So yeah, it doesn't actually state court days this time. It says Sundays and public holidays. So you got to actually figure that out. Colleagues, you understanding that?
Hi, Prof. So it means that we're including Saturdays when we're calculating the 120 days.
Yeah. So it includes Saturdays, but disregarding only Sundays and public holidays. Yeah.
Okay.
Sorry, Professor.
Yeah.
If I can just make a friendly request. We're dealing here with road accident fund and personal injury claims. There are some of my learned colleagues posting in the
chat,
in the chats about DocSeat and casework and things like that. It's very disturbing. If we can please refrain ourselves and focus on the topic of the 2 days, please, guys, please, colleagues.
Okay, thank you, Richard. I think, yeah, let's just focus on this, colleagues. If there are other questions, I think that's not related to the subject. Let's find another way to do it, or even at the end if you want to. Okay, so colleagues, there's something important actually in section 17.2 of the amendments that came into play after 1st of August 2008. And that section said that costs cannot be recovered unless a summons is served. Now, what that means is that in the past, right, before the amendments, let's put it that way. In the past, let's just say I was the attorney, I was assisting my client, we lodged the claim, and we were having back and forth correspondence with the RAF, but I hadn't actually started the litigation process. In other words, I didn't go and actually issue the summons. And then let's just say that we actually settled before we issued summons. In that instance, previously, before the amendments, you could actually claim some of your costs, right? Party and party costs it was limited to. But now in terms of the amendments, they took that away. So you can only claim your costs now from the RAF in your summons, etc., only if you've actually issued and served the summons. So that's important. Just to note there, keep at the back of your mind. And then our colleague that was speaking about different parties, and I said to him, we're going to deal with that next. So here we're dealing with third parties who have locus standi. And the question is, who is considered a third party? So as a start, just as a general rule, every natural person that has a full legal capacity, they have the capacity to litigate, they can be considered a third party. Someone that doesn't have a full capacity, the limited capacity, remember, our children, or someone that has a mental disability, whatever the case may be, they would need assistance, and there we would have to appoint somebody on their behalf. So who is entitled to claim? Remember, right from the beginning, I said there's two types of people, two types of third party, remember? You want to just repeat it for me again? Anyone take a stab? Colleagues, am I audible?
Prof.
Yeah.
It's parties who are claiming for personal injury and those who are claiming for loss of support.
Okay, perfect. Okay, she said it perfectly. Bodily injured third party, the first set or the first category that we look at. So this is where you can actually include an unborn person. Why is that? Anyone want to get a stab as to why an unborn person actually has locus standi, and when do they have this locus standi?
Based on the
Is it
fetus.
not an ceteris fiction?
Yes, yes, you're right. So whatever happens to that child, remember, it's held in abeyance. As soon as the child's born, then it's applicable. So an unborn person can qualify, a minor, the guardian of the minor in his own right, a person married in or out of community of property, an unrehabilitated insolvent, and then that doesn't actually need to be a closed list, but it's just examples of some of the odd in and outs where you get questions. So it's not a closed list. You just have to look at whether they comply or they do have the locus standi. Then there are third parties who suffer loss of support, just like how the lady said, where you're claiming loss of support. And there the claimant can be legally married. There's a civil marriage. It's marriage according to customary rights. The Customary Marriages Act, whether it was registered, it depends on what is the type of marriage regime as well, whether there's an ANC involved, whatever the case. But bottom line is considered a third party through and through, yes. Partners in same-sex union, that came from the case of du Plessis. Live-in partners, duty to maintain contractually. So in the case of Honoree versus Santam, I think it stemmed from a divorce settlement agreement, where the husband, the ex-husband, was supposed to pay the wife, I think it was something like 400 Rand a month or so. I can't remember the full value actually. It was such a long time back. But the principle is that if the wife or the other spouse, even if it was the husband, if the other spouse was entitled to funds according to that divorce settlement agreement, which is a contract, and now the spouse has died, that other spouse who is entitled to those funds can claim the loss of support based on that contractually created obligation. Then you have parties that a relationship is solemnized by other rites, and there I'm talking about Hindu and Muslim rites, because there it's just done with a Molana or whatever the case may be. Then you have other dependents, which is parents or other family members. Now, in some of the customs, especially in African customs, it's such a big thing that you see quite often, and it's grandparents that receive support from their grandchildren. And to other people that might seem odd, but it actually happens that there are grandchildren that do support their grandparents. And then there's children and spouse on the death of one parent, as well as adopted children. So sometimes you might think, but what is it that connects it? So when it comes to third parties, the important thing to declare, even in your particulars of claim, that important thing to mention and to actually prove is to show that duty of support, that duty of support was in place at the time of the accident. That grandchild was sending his grandmother 2,000 Rand a month to help with her medical expenses, and now that grandchild has been injured in an accident, and that grandmother has lost that 2,000 Rand a month. So that's the kind of scenario that you can get, and the kind of duty of support that you must prove. And then there's other third parties. So you get executors of the estate. Now, if the deceased was treated at a hospital and then later died, only the executor has the locus standi to claim the past medical expenses incurred, as well as the funeral expenses, right? So there's even a time when the executor can qualify as the third party. He has the locus standi for just that hospital expenses and that funeral expenses. And then it's curators, heirs as well, owner of the vehicle injured, a supplier, which is the medical doctor and the hospital. They are not third parties. And locus standi, oh yes, important colleagues, locus standi, it is not an absolute exclusion, it's a relative one. So if you can rectify it, so lack of locus standi doesn't mean that's not a valid claim. You just have to rectify the situation and make sure that the right person who has the locus standi then continues with the claim. And the RAF will not pay until that locus standi is established. I haven't seen a lot of issues where they have this problem, but it definitely can occur because there's so many different people involved. And then child out of wedlock with no birth certificate. The RAF will accept affidavits, and that's from the maternal grandparents, as well as other family members, to the effect that the mother is the biological mother. And then paragraph 8.3.9 deals with the foster parents' locus standi. They actually do not have locus standi to claim on behalf of the child. The foster parent does or is able to claim in his or her own personal capacity. That would be for, remember we discussed past hospital and expenses. If they personally paid for that, they can claim those damages. So if the natural parent cannot be found, then you have to appoint a curator. Yes, I think there was a question coming.
Yes, Prof, it's not the I wanted to ask, with regards to the foster parents, what would be the procedure for them to obtain guardianship? Because I'm under the assumption that if they are legal guardians, then they would have locus standi and then be able to claim in both capacities as a guardian as well as well in their personal capacity. So what is the procedure and like the timelines that they would need to adhere to in order for them to be recognized? This is my question essentially is, would it also be possible soon after the child gets into an accident, the minor gets into an accident, can they get guardianship, legal guardianship after the fact, or they would need to have been legal guardians before?
Yeah, they need to be at the time. It doesn't happen ex post facto. Yeah. They, in the instance where they are not the legal guardian, then you have to appoint a curator. You must then continue with the claim before prescription. But I'm not sure of timeframes of when the legal guardian. I think that's probably for family law expert. I have to ask one of my colleagues. Colleagues, are you
Thank you
still with
very
me?
much.
Yeah.
No.
It's an interesting question, actually. I don't know myself what is the procedure to do that, to become the legal guardian, and how long the timeframes are. It's an interesting question. I'll probably have to ask Prof. Heaton about that. But I made a note
Can
of
I
it.
interject? I know the process.
Yeah, please do.
Lovely.
It all depends. Like I have foster care for my sister's kids. What happens is the first step is social workers must come in. Then they will evaluate the situation. They will do reports, and they'll have to call extended family members to find out if everything is the truth. After that, you will have to provide all the necessary documentation to support that they have no one, the kids have no one to look after them. And if the parents are alive, that the parents, they are not in a position to take care of their own kids. After that, you have to obtain a certificate of clearance from the Department of Social Development that you are not a sex offender. Otherwise, they won't, you won't even be able to go to court. Then the people from child welfare, that's when they'll come in, they will lodge the papers for you in court. You will get a court date, you go to court with the kids, and the magistrate will ask them questions. And if she is satisfied, the first time around, you get 2 years as a foster parent. Then after that, they will give you until the age of 18.
Wow,
So
thank
that's
you.
how it works.
Yeah. If you have something like a link to send to the colleagues in the chat box, please do post it where they can get this information, even if it's for your future use, for future reference. That's brilliant. Thank you. At least I don't have to ask Prof. Heaton and come back to you now.
Prof?
Yeah?
Sorry to take you back. It is just something that maybe I might have missed that train when you were busy explaining. I think it followed the answer that was given by one of my colleagues here when she referred to the fiduciary duties of the trustees. So my question is, I realized that the question of RAF is mainly centered on medical expenses and the damages.
Yeah.
The question that I have is, I think someone alluded to it. Now, in the event that the parents, it still goes back to that parents claiming in their personal capacities and also claiming on behalf of the kid, the minor child that is injured. So now there's you find that now the parent has to modify the house. The house was a double story.
Yes.
Now they have to build a ramp in order, it had stairs. Now they have to build a ramp for the kid to be able to maneuver using the wheelchair. You know, it is necessary for that and for the upbringing of the child. Wouldn't that qualify as something that a parent can actually put in their claim to the RAF? Yeah.
Yeah. It is definitely something that can be claimed. In fact, it happens a lot because especially when you'll be dealing with a paraplegic or a quadriplegic, you have to definitely make those modifications to the house, and that can definitely be claimed. It's a very good question. I don't normally cover it in the slides, but really good question, and definitely yes, the parents can claim for that. Especially since there's so much expenses involved in doing that, and it's necessary. And it's going back to the principle of damages, where you must be in the position you should be in if the accident hadn't occurred. Now, that's not obviously able to put you in the position that you would have. You don't have your legs and arms maybe working, but it's to just make you as comfortable as possible as you can. Yeah, so it's just some kind of a measure at least. So yeah, wonderful question. Thank you.
Yeah, Prof, I just want to throw out something there is, you know, it's all about the reasonableness. The
it
cost
has to be reasonable.
What would the reasonable person's cost would have been? It's all about the reasonable.
Yeah.
Nice,
Yeah, so
nice,
it's
nice question
reasonable.
there, my learned colleague.
Thank you, Richie. Thank you.
Okay. Yes, it does come down to reasonable cost, colleagues. That's also part of basic principles of damages as well. Basically has to be reasonable, and you must mitigate your costs wherever possible. Yeah, basic principles of damages. Wonderful, colleagues. Okay, now we're dealing with another section, which actually somebody did refer to it already, Apportionment of Damages Act. Remember we said that when negligence applies, and the standard of negligence is usually the reasonable person, it can even be the reasonable child if you're dealing with a reasonable child. So the standard is whatever standard, but it's the reasonable person or reasonable child. And how far did that person stray from the reasonable person or the reasonable child? So if we take an example, let's just say, remember my one case I mentioned to you earlier where there's mutually destructive versions. And I said, in that case, you'll apportion the damages 50-50. Now, what does that exactly mean for the plaintiff? Let's just say, let's look at the example actually that I've got on the screen. The plaintiff is found to be 20% at fault, and the proven damages are 100,000 Rand. I'm already giving the answer though. Apportionment applies, it's less 20%. So in other words, it's the 100,000 less 20,000 equals 80,000. And can somebody explain to me why is that? Why is the plaintiff's damages reduced to that amount? What actually happened there?
Prof,
Hopefully
if I
the
can
math-
take a shot
math-
at it.
Go for it, yeah.
So if we can say, all right, so as stated here, the proven damages is 100,000%. Or 100,000%. Oh, apologies. Oof, it's getting
Don't
late
worry.
at night.
Yeah, no, I
So
understand.
proven damages to the value of 100,000 Rand. The plaintiff is found to be 20% at fault. Now you look at the defendant. Let's say the defendant was, okay, 80% at fault. So the 20% and the 80%, that's 100. Now we can say, okay, you as the plaintiff, you were 20% at fault. Out of this 100,000 Rand, you have to pay 20% of this 100,000 to the defendant, and the defendant is 80% at fault, so he needs to pay you 80,000. But to simplify everything, they say, okay, if you're 20% at fault, we cannot give you the full 100% because you were not completely faultless. So that 20% that you were at fault for, you cannot ask for those damages. So we subtract it. That's where the 80 comes from.
Lovely. You explained it so well. Colleagues, did you follow that?
Yes.
Okay.
Yes.
Okay, so
Jan
that's
is, Jan is for the next lecturer.
yeah, keep that in mind. Colleagues, that's just a basic example. It can get very complicated, actually, but I don't want to get into that because then we start dealing with maths and then everyone gets very confused, but that's just a basic principle. There's a question that I want to ask you, though, with regard to apportionment of damages. And if we're looking at the plaintiff and the defendant, does it always have to add up to 100%? The plaintiff's portion and the defendant's portion. Does it always have to add up to 100%?
No, Prof.
No.
Yeah, you're right. So what can happen is that your standard is there's still the reasonable person, but the court can state that the plaintiff is 60% at fault and the defendant is 70% at fault. It doesn't equal to 100, but that's perfectly fine. But the main thing to remember is the plaintiff's damages are reduced depending on his degree of fault, basically. So that's how it applies. But our colleague that explained it did a brilliant job. Thank you. So just bear that in mind always. And then before I move out of the slide, we have to talk about children. Do you remember from law of damages, law of delict, this whole story of accountability of children. So from 0 to 7 years, there's a presumption that applies. The child is, or it's not a presumption, it's actually a given. From 0 to 7 years of age, the child is unaccountable. But from 7 to 14, the child is culpe incapax, unless the contrary is proven. So it depends on the maturity level of the child, basically. And then also a child between 14 and 18 is presumed to be accountable unless proven to the contrary. So I think you remember that. when we're dealing with criminal law, this age group applies differently. Can anyone tell me what is the age group for children in terms of criminal cases? What happens for criminal liability of a child? Here we're dealing with delict, so we know that this is what applies. But for criminal liability,
7 or 12.
So what
Depends.
I saw somewhere, I think it was Prof. Neertling that wrote an article. I think he said it is when it comes to delictual liability, we must follow the 0 to 7, 7 to 14, 14 to 18. But when it comes to criminal liability, there's a different thing that applies. And I think it was 10 years old, where it's 0 to 10. It seems like they are more lenient when it comes to criminal cases. But there is this obviously discrepancy, or what can I say, contradiction in our law, that we have these two differing things that apply. And some people obviously find it unfair that why should you treat it differently if it's a delict and different if it's a crime. Obviously, some people say, well, a crime is, it's a crime, basically. We're not dealing with money. It's against the state kind of thing. But yeah, just always bear that in mind, that different rules apply for delict and then different rules apply for criminal liability, at least in terms of accountability of a child.
Professor, I must come in there and I said 10 or 14. And
Okay.
when it comes in, it relates to the Criminal Justice Act.
Right.
The child, the
Child Justice Act, isn't it?
Yes, yes,
Yeah.
the Child Justice Act, where the mediation takes place and things like that. And yeah, and that's where there's a conflicting issue in terms of the Criminal Procedure Act and the provisions relating to the Child Act. Yeah.
Yeah, you're right. So just bear that in mind, colleagues, at the back of your mind. So much information you need to have there in the background, right? Lots of it. But thank you there. And then we're talking about, remember earlier on I said you need to know all these different areas of law, because law is never simple. It must involve various areas of the law. Now you've got to try and put everything together. Magistrate and High Court rules. Have you already had those lectures, by the way?
Indeed, we have had them, Prof.
Okay, brilliant. That's why you
Youngest, I
guys
cannot
know a
recall
lot.
you being there.
But that's why you guys are really up to date with things. Okay. So High Court and Maj Court practice. I don't need to go into that because you guys would have known that there's a big difference between them. Just remember simple things like there's procedures that apply. You can apply joinder. One of the most common things to do in practice, especially with road accident fund claims, because it can be extremely complicated. You can have a case where you're not sure if locus standi is even applicable, or if you actually stating that the wrongdoer driver was negligent. You don't even know if faults in the inquiry. It might be that it's so complicated dealing with fault itself. You need reconstruction experts and everything. So normally what happens is they say, right, we're going to separate it and we're going to deal with the merits first and then later the quantum. So the merits of the case will deal with whether you have locus standi, who's at fault, etc., and how much fault. And then later on, now you go back to court and you deal with a quantum. And there you have a whole list of experts, and there you're just basically proving your damages. So that's a very common thing that happens with road accident fund claims. Uniform rule of the High Court 41A, I think it's mentioned in paragraph 4. That really just deals with referral to mediation. The courts, there's just been a trend not to litigate so much, to reduce the court time, to reduce everything, basically simplify issues. So one of the things they impress upon, obviously, is the mediation. So with regards to that, I'm sure even in your High Court rules, you must have come across it as well, or they've told you about it. But there's a notice that must be served. And obviously, if a party opposes this mediation, reasons must be provided why it cannot be mediated upon. And it's a specific notice that then gets filed, etc. Where the parties agree to the mediation that must take place, they must actually provide a joint minute. So the joint minute is really where they're noting down what is an issue, what needs to be simplified, what is the problems that still need to go forward, whatever the case may be. If a dispute is resolved, and then what happens is a settlement agreement is drafted, and then that is the end of the matter. It doesn't continue on with litigation then. Interim payments and undertakings. Remember earlier we spoke about this a little bit, we touched on it. With past medical costs and loss of earnings, right? There you can apply. What happens is this only applies in instances where liability has been established. In other words, the fund has conceded the merits. They've said my driver is 100% wrong, the wrongdoer driver is wrong. And in those scenarios, then we may continue, and we can continue with interim payments to help you in the meantime till this thing is completely resolved. And then undertakings will apply for future medical expenses and future loss of earnings. And the lady asked me about that as well, the future loss of earnings, and that can also be done in terms of installments. And we had a nice conversation about how it must be put into trust. So that was brilliant because I didn't have it on the slides, and it's not actually discussed in detail, I think, in your practice manual. So that was really brilliant. And then one of the questions we had earlier on, one of the colleagues spoke about caps on loss of earnings in terms of the amendments. And there we've got, I've just said to you, check paragraph 5.9.2, but we are going to discuss that still a bit further down. Yeah, before I continue with this next concept of damage or damages, colleagues, any questions?
Prof, it's time, it's 8:30.
Oh, yeah, 8:30.
It's
You know what?
8:30.
I literally picked up the phone and I'm like, hey, we're supposed to be done now. Okay, this is nice, colleagues. We are at a nice place. We are not doing too bad. We can pick up tomorrow on damage and damages. So any questions, burning questions that need to be answered now, colleagues?
I have just one. Sorry, guys. I just want to understand in terms of like lodging a claim in the High Court, right, Prof? I am a bit confused on whether you need the court that has jurisdiction is the one where the collision happened, or it can be any High Court in South Africa.
Yeah, it can. So there's like rules as to what is the terminology for that now? Where the defendant resides. And
Yes,
the defendant
right.
resides literally, there's so many regions and branches of the RAF. So it's literally the whole country.
Okay, so it doesn't necessarily like that High Court in order for you. So then how do you establish jurisdiction? You're just gonna establish it that the claimant or the defendant resides in that well, it's RAF in this instance that they hold their offices there.
Yes, yeah.
Oh, okay.
So sometimes if you look at some examples in your book, I think they actually mention the whatever is the road accident fund and has jurisdiction, and they even provide an address there. I've seen some like that, but yeah, literally there's regions of offices all over the show. Yeah, so that's never really an issue. The previous does not exclude Sundays. Oh, colleagues, I'm just looking at the no, but I think we dealt with that. Is there anything that I haven't dealt with that's on the chat box, colleagues? Remember I told you I can't see the chat box.
Sorry, ma'am. I think there was a question on why Saturdays are not excluded because it excludes Sundays and public holidays.
So
I don't know if it has something to do with the operating hours of the RAF offices or what, but it's a question.
I think that's where it might be coming from, and it's specifically stated, yeah, for the how to calculate that 120 days. Okay. Yeah, that's the reason why. And then somebody said here, does the RAF not have a non-fault policy? That is a really interesting question in the sense that at the moment, it still investigates fault. It still is important to find out who's at fault. But future legislation, they are actually intending to scrap fault completely. But I'm going to explain that in the that bill. So that will be covered. Okay, that's it, colleagues. I don't want to keep you any longer. I'm sure some of you are exhausted for the whole day.
You can
Okay,
say that
good.
again, Prof. You can say that again.
No, I know it. It's going to be a grueling month. I can tell you that.
Thank
Good
you, Prof.
evening.
Thank
And
you, Prof. Good evening,
Thank you,
everyone.
All rise.
I'm sorry to be out of order.
Thanks. Good night, everyone.
Thank you,
Bye.
Prof.
Night, colleagues. Good night,
Thanks.
Professor.
Good night, guys.
Good night.
Good evening.
Hi.
Guys, you just an SMS from Professor. With